front of Judge D'Agostini in the 48th District Court on the 30th. And she does schedule her exams, and they do start on the date and time that she has them scheduled for. That I know.
Tell you what,
yeah.
This doesn't look like it should take a long time, so I'll make it at 8:45 on the 30th.
Okay.
And I'll have you out of here by 9:30.
All right.
Okay?
Awesome. Thank you, Judge.
All right, so that's what we'll do. June 23rd at 8:20 and June 30th, the preliminary exam for which you both have to be here will be at 8:45.
All right. Thank you, Judge.
Thank you all. Thank you. Have a great day, Mr. Savage. Good to see you.
Good to see you. Bye-bye.
Do I have anything else down there?
No, Judge.
Mr. Kelly, you're here on what?
I'm here on Clinton, Your Honor. It was set, I believe, for a show cause for this morning because our client didn't appear before the timeline required underneath the ticket. It's a state hearing. He's an out-of-state defendant, and there was some confusion on when he needed to be here. So we've stepped in to help him with this matter.
Did you talk to the prosecutor?
I've not spoken with the prosecutor yet. I don't think our client's been arraigned or anything on this matter.
I put Mr. Kelly in a breakout room. He just needs to join.
Yeah, you join the breakout room and you can speak to the prosecutor and you guys can see what you can work out, okay?
I didn't see it pop up. I'm sorry, Your Honor. Thank you.
All right.
I have to drop my daughter at cross country in 4 minutes. Can I sneak out and do that and come back in about 10?
I'm sorry, say that again.
I have to drop my daughter at cross country conditioning. Can I drop her off and pop back on in about 10 minutes? Is that okay?
Sure. I'd rather you just get back to your office. How far are you from the office?
Oh, I'm at home. I stayed and I'm not moving right now. I'm sitting here. I was
Go
going
ahead and go and then come on back to the office rather than in the car, okay?
Wonderful. Thank you so
or
much.
Your house, whatever. Okay, thanks.
Thank you for your help. I'll see you in a minute. Bye.
Okay. Good morning, Trooper.
Morning, Your Honor. How are you?
Good. Yourself?
Okay. My Trooper did a pretty shoot. Yes. Do you talk? I do.
Okay, people against Naila Majid Chowdhury, 26M682200.
This way.
All right, Trooper, come on up to the podium, please, and tell me your name. How are you?
Good, yourself?
Good. You,
Sergeant Micah Keller, Michigan State Police.
ma'am, your name?
My name is Naila Chowdhury.
Good morning to you. The charge here is failure to yield right of way. Was anybody hurt in this accident, Trooper?
Yes, Your Honor. It was a Brownstown Police Lieutenant. He had minor injuries to his hand for the airbag deploying. I believe his thumb.
All right, so, ma'am, this has nothing to do with the fact that it's a lieutenant from Brownstown. It has everything to do with the fact that I don't reduce these accidents if somebody's hurt in the other car. Okay, so you can either plead responsible to it, or you can go forth with the hearing if you would like.
So I'm just here for forgiveness if you forgive.
You got to keep your voice up for me.
I'm here for forgiveness if you forgive my points.
I can't do that, ma'am. When somebody's hurt, I won't do that.
It's my first time. I'm doing 5 years driving, so we never got any.
Ma'am, I've been doing this for a long time and I've never changed or wavered in my policy here. I just will not reduce it when somebody in the other car is hurt. I'm sorry. So you can either plead responsible or you can go to a hearing.
Was my all, my.
Did you hear what I said? Did you hear what I said?
No,
It's okay that you disagree with me. People disagree with me. Do you want to plead responsible or do you want to have a hearing?
I'm responsible.
All right, to the charge failure to yield, responsible or not responsible? You plead responsible or not responsible? I'm sorry?
Responsible.
Okay, I'll accept the plea. Your total's 195. You can go down the hall and make that payment, okay? Good luck to you. Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Have a good day. Today is the 15th, 16th. Jim. See the changes in 7th. 16th, if you can figure it out.
John, you put that one up now.
Absolutely. Yeah, well,
Quiana Victoria Vassar, 23F 2414110A and 23B 1444426A and 123F 2413331 and 23F 241410B and 23B 1444426B. Your name, ma'am?
Quiana Vassar.
Ms. Tucker Davis, are you on this? Who's on this? Oh, you, Mr. Westmoreland. Okay, I'm sorry. Your appearance?
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Vassar.
Okay. So she just doesn't like to show up, it looks like. Would you tell me how she wishes to proceed?
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
I'll enter not guilty, please, on all of these for her. So let's just start by you explaining why this young lady doesn't think she has to show up in court.
Your Honor, she was living in Garden City at the time. I know that's no excuse, but her car broke down. She didn't have any opportunity to get here. I did explain to her that this honorable court does allow Zoom, so that may be a good option, but she is currently residing in Flat Rock. She is gainfully employed working at Tim Hortons. Moving forward, she knows that she needs to appear and take care of all these matters. She can start making payments next week, Friday, when she gets paid. She acknowledges that she owes the money. She's not currently on probation or parole at this time. I just ask that all that be taken into account.
Ma'am,
Yes,
I don't appreciate this.
I
Okay,
know. I apologize.
well, I hope you got some money with you. You put yourself in a horrible position now. You really did. Really did. And you got cases from 2023, and I don't want to hear this about not having a ride. You certainly were driving through these local cities and townships around here in 23 and 24. How long have you lived in Flat Rock?
I want to say since 2016.
And you couldn't get here from Flat Rock.
No.
If I'd have told you was going to give you $1,000 to get to the court, you would have gotten the Woodhaven, wouldn't you, for these, wouldn't you?
Well, not to pay me. I should have tried to walk.
Yeah, I know. That's my point.
Yeah, I apologize.
Don't apologize to me. You might be apologizing to yourself if you can't come up with the money. But it's needed. It's no skin off of my neck. All right. You have 2 cases assigned to Judge Hessen. Those are 23B 144-426A and B. On that one, you owe $327, including the clearance fee at least, plus $213 for a total of $540. I'll cut it down and set a bond of $1,500, 10%, which will cover the A file and the B file. You have a case in front of me for which you owe $213. I don't know. I guess this one's also in front of Judge Hessen, 23F241331. I'll cut it down and set 1,000, 10% on that one. The drivewall suspend has never been adjudicated, so I will incorporate on 410A, Lisa, I'm setting 3,000, 10%, and that will also cover the 410B file. So looks like you owe $550. I will give you the earliest court date I can. We will give you pretrial dates on the Flat Rock case for June the 18th. June the 18th at 10:45. That's this Thursday. I will likewise set the other ones June 18th. At 10:45. And the other one as well, June 18th. All these will be June 18th at 10:45. I hope you can post. They're going to let you make some calls, but you just can't do this, okay? I hope you're going to learn a lesson. I hope you can post the bond. I really do. But
I hope I can too, but I have learned my lesson.
I'm sorry.
I said I'm gonna do the best I can to post the bond, but I have learned my lesson.
Good luck to you. Thank you.
Thank you, Judge. Have a good
Thanks.
morning, Your Honor.
You too. Thank you.
Take care, Gary.
Lisa, would you do me a favor? When you get a minute, would you call over there and tell the sergeant and lieutenant if she can get up to $300, I will reduce the bond.
Okay.
Thank you.
Ms. Ford, do you need to speak to your client?
Ms. Ford, can you hear her? Ms. Ford, can you hear my judicial clerk? You're gonna have to messenger, I guess. I don't think she hears. Ms. Ford, can you hear me?
I just sent her a message.
Thanks. I don't even think she's looking.
She was just in a breakout room with the prosecutor.
Okay.
Can I get your name on the Pixel 7 phone?
Pixel 7, we need your name. You need to unmute and tell us your name. Does anybody read the notes?
It's going to be
that
one
was-
of those days.
What's your name, sir? You have to tell us your name. We're not mind readers. You're going to have to unmute. What's your
No,
name?
I'm sorry. I was on a call. This is for Tawa Trucking LLC.
Are you a
I
lawyer?
was trucking.
Yeah,
Aren't you guys the ones I told had to have a lawyer?
No, you said the president.
Yeah.
I
It's,
would,
Are you the
it's a civil
president?
infraction, Judge.
no, I
Okay.
have the president here with me.
Okay, we'll have the president get in there and we'll put you in a breakout room with the prosecutor, okay?
Yes, sir.
Thank you. And he has to have his hat off if he has a hat on. Miss Ford, can you hear me?
Yes, we're going into the
Breakout,
Break room.
good.
So
Sheila
Walker. It was on that one before we had the exam set for next week, but it just retained out. That's why. I'll call her right now. Log back in.
Do I have an appearance from her, Lisa?
She was emailing me one. I haven't received it yet. That might be what she was trying to do in the car. She said she just got retained late last night.
Well, that's all fine and dandy, but I can't let her appear unless she's got it in.
I did tell her that. I told her I need an appearance before you can go before the judge, but I haven't received it yet.
Is there a man out there?
Yes.
Thanks, Sean.
So, oh, it works?
Yeah.
Yeah.
I'm here. Your name?
Michael Willoughby.
You don't have a lawyer?
No.
You already met with the prosecutor?
Yes. Didn't make it today.
He was pro per.
You have the right to an attorney. If you want one, I will give you one. Would you like an attorney to represent you?
No, thank you, sir.
Okay, so I'm going to go ahead. If you want me to take this plea, I'll go ahead and take it. Do you wish to stand mute and waive reading of the complaint on the drive while suspend charge? And then I'll go into your plea agreement here. Is that what you want to do?
As I spoke with the prosecutor.
I know. Do you want to waive your reading, or you want me to go ahead and formally arraign you on the driving on a suspended charge? Okay. So I'm entering not guilty plea for purposes of arraignment. Now, as I understand it, you're going to plead guilty to the charge allowing an unlicensed driver to drive, with the understanding that the suspend charge and the seatbelt charge will be dismissed. Is that your understanding, and is that how you wish to proceed?
Yes, sir.
So if you plead guilty to this charge, like I said, I'll dismiss the suspend, dismiss the seatbelt charge. Possible penalties on this, allowing an unlicensed driver to drive, are up to $500 in fines, 90 days jail, costs are all those. And then I would go ahead and dismiss the suspend and seatbelt. This will not get reported to the Secretary of State. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you will be giving up all those rights, and there will not be a hearing. Do you understand that?
No, I understand.
You have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes, sir.
Jen, can you cool that down a little bit? It's hot in here. To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
On May 25 and 26, were you in control of a 2016 Chevy black in color that was being operated on I-75 near Gibraltar Road in Brownstown?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
I'm in sobriety program.
Okay. Were you on probation on May 25th of 26?
But technically, no, that would be considered probation.
How long have you been in sobriety for?
7 months now.
Okay, so you're on probation though, right?
Yes, sir.
All right. So you understand if you plead guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction.
Yes, sir.
You still wish to plead guilty?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
I'll accept your plea. Where are you in sobriety court at?
25th District Court, New Park.
Did you get transferred over there?
Yes, from Rwanda.
Why are you driving on a revoked license?
I was offered interlocking my vehicle. I was just getting in.
Yeah, you can't drive those, sir, without an interlock device.
I actually have a breathalyzer 5 times a day. I cannot show the officer.
It's a SoberLink device, right?
Correct. It's
Okay, but you got to make sure you got all that ironed out with the court and the Secretary of State. You're revoked. You can't drive. Where were you going?
just to one beer,
Going where?
the lake, one beer that day.
Did you tell Judge Clifton about this?
Yes, and
He knows? And the probation department knows? You got to answer out loud.
yes,
All right. You can't be doing this. Anything else you want to tell me?
that's it.
You got to get your SoberLink, your interlock. Okay?
Understood.
100 fines, 210 costs, 75 victims' rights, $50 justice assessment, 435 or 60 days. You can pay that now?
Everything once.
And I'm dismissing again the suspend and the speeding. How much do you have today?
Can you $50
I can't hear you.
$50 or not? I think is a payment plan.
And then how much per week?
You do 25.
Where do you work?
I work at
What do you do?
front desk supervisor
Where?
at the Hampton Inn.
How much per week?
About 18 and on.
How much?
18 and on.
All right, you pay 50 now and pays 25 per week. And I'm going to start that beginning on June the 29th. Okay? That's on a Monday. If you ever need more time, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay? Good luck. Teresa Lynn Vaz. So you're all set. Go down and pay your $50. Teresa Lynn Vasquez, 26G 712-982. All right, counsel, your appearance again.
Attorney John Cavalieri on behalf of Teresa Vasquez, who's present in the motion.
Your name again, ma'am? All right, so the prosecutor approved this. You changed it. I'm going to go ahead and sign your discovery order. And you can take this down the hall. We'll give you a copy. How long do you need? 3 weeks?
3 weeks, please.
When would that be, Lisa? I got to give you 4, but I can't adjourn it again, okay?
Understood.
So we'll make it, is it July the 14th, Lisa?
Yes, on July 14th at 8:30.
30, okay?
Thank you, Judge.
And I've signed your order and you are all set.
Thank you, Your
Have
Honor.
a good day. Good luck, ma'am. Bonds continued. Did we receive Ms. Ford's appearance?
Yes, I received it by email.
Dari Alonzo Emmanuel Mann, 26B 712-364. Mr. Hussein, you have to take your hat off, sir. All right. Good morning, Ms. Ford. Your name?
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Derry Mann.
Mr. Mann, your name?
Derry Mann.
We've had 3 lawyers on this case, it looks like. I hope this is the last one, right, Ms. Ford?
Yes, Your Honor.
I'm a little concerned. I'm not going to be here the week of the 7th. I'll do a PCC next week. Sir, remember when I told you you had the right to a probable cause conference within 14 days
Yes,
of the
sir.
date of the arraignment?
Yes, sir.
Your lawyer needs an adjournment now. You just retained her, correct?
Yes, sir.
So if I adjourn it again, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
You waive that right. You waive that right?
Do you agree?
Yes, sir. Yes, sir.
Could you not hear me, or do you have a question about waiving that right?
Yeah, I have a question to Ms. Ford.
Well, I don't want you to talk to your lawyer about legal advice in front of me.
Sure.
If you don't want me to adjourn it, I won't adjourn it. I'll be glad to go with the exam next week. That's fine with me.
I will not be prepared to go to with the exam 110 pieces of new evidence by next week.
Fine, I got it. But your client, he's either gonna waive the right or we're gonna do something else. I mean, I can't make him waive his right.
I waited.
Are you sure?
Yes.
Anybody force you to do that?
No, sir.
All right, so counsel, I'll adjourn the PCC to the 26th. I'm sorry, the 23rd. We can do this at 8:30, right, Lisa?
Yes, 8:30.
I can't do the exam until the 14th. If it says that the OIC is out of town, on the 30th, so the prosecutor doesn't want me to set it then. I'm not here the 7th, so we'll have to make it the 14th. Are you available that day, Ms. Ford?
Yes,
Tell me
Your Honor.
yes. Good. July 14th. I'll do that for you. And we'll have it July the 14th at what time, Lisa?
10:30.
10:30. Okay.
Thank you.
So we're
Thank
going to do
you.
the exam next, or the PCC next week at 8:30. On July 14th, Mr. Mann, you have to show up in person. You understand that, correct?
Yes, sir.
All right. We'll see you guys then. Anything else, Ms. Ford?
No, Your Honor. Thank you.
Thank you. Bond is continued.
Bye-bye.
Bye now. I can't. All right. Okay. Hamad Hussein, 260-241-071. Good morning, sir. Your name?
Good morning. Hamid Hussein.
The prosecutor just says you're in compliance with the law, failure to display a number or decal. And so she's moving to dismiss. That's her prerogative. Case dismissed. Motion of the plaintiff. You're all set. Good luck.
Thank you, sir. Thank you very much. I appreciate that.
Thank you. Tawas Trucking LLC, 26S118458. Mr. President, your name?
Justin Sheets.
You are the president of Tawas Trucking LLC?
Yes, sir.
You're authorized to enter into this plea on behalf of the company?
Yes, sir.
The charge exceed posted bridge, posted 23 ton. How do you plead, responsible or not responsible?
Responsible.
And the agreement is that there's going to be agreed upon fines and costs of $1,700, correct?
Correct.
All right, I'll accept the plea. Fines cost $1,700. I'll give you until July 16th to pay this, okay?
Okay, thank you, sir.
Have a great day. Good luck.
Thank you.
Anthony Allen Leonard Jr., 26M704924, A and B. Good morning, Mr. Graziani.
Good morning, Judge and staff. John Graziani appearing on behalf of Anthony Leonard. This is my left. Please identify yourself, sir. Anthony Leonard Jr.
All right, so did you see him in waive formal reading?
Yes, he does, Judge.
So I'm entering a not guilty plea, and now he's going to plead guilty to no valid ops with the suspended speed to be dismissed. True?
That is correct, Judge.
Is that what you want to do, sir?
Yes, sir.
If you plead guilty to no operator's license on person, the possible penalties are up to $100 fine, 90 days jail, costs are all those. And if you plead that, I'm going to dismiss the 2-point misdemeanor of driving on a suspended and the speeding, which would also carry 0 points, but it would go on your record. Do you understand that? It's limited access.
Yes, John.
And did you sign, read, and understand an advice of rights form here today and review them with your lawyer?
Yes.
If you plead, you'll be giving up all those rights on the advice of rights, and we're not going to have a hearing or a trial. If you understand that. To the charge, no valid ops on person. How do you plead? On May 25 and 26 at 2:05 p.m., were you operating a motor vehicle on I-75 near Gibraltar in Brownstown?
Yeah.
Did you have a valid operator's license with you on your person?
No.
Are you on probation or parole? Anybody forced you to plead guilty?
No, sir.
Please accept it. Why don't you show up in court? You got warrants all over the county.
Say it again, sir.
I said, why don't you show up in court? You've got warrants all over the county.
Well, I was, I got pulled over here at Woodhaven. I found out the warrant in the warrant.
You have all kinds of warrants.
I only found out about 2, sir.
Well, you got a bunch.
I've told him, Judge, to start addressing.
I'll accept your plea to no ops, dismiss the suspend, dismiss the speed. You got a warrant on Macomb County front of the court.
Yes.
Hazel Park, Detroit, Highland Park, Detroit, and Detroit. Where you come up with you only have 2 warrants? I just counted about 7.
Officer told me that's how I came up with the officer when I got pulled over. That's what he told me. I only knew about Macomb and I knew about Hazel Park.
And go to Highland Park and go to 36th District Court. You know where that is, right?
Yes, sir.
You don't remember getting ticketed there and not showing up?
No, sir.
Mr. Leonard? You don't remember getting ticketed there and not showing up?
In Detroit, I didn't receive any tickets or the cards that for court in the mail at all. So no, I did not know I had a court there anything at all. Such as
Mr. Leonard, I'm not gonna about to quarrel with you here. I'm only telling you
Judge, thank you.
thank you.
that you need to go over there and take care of your tickets. You got one in July of 24, you didn't take care of. You got one in May of 25 out of Detroit, you didn't take care of. You got another one on August 19 of 25 out of Detroit, you didn't take care of. You got another one on August the 19th, another one in May. So you had 3 different stops, 5 different warrants out of Detroit alone, not including Macomb, not including Hazel Park, and not including Highland Park. Right?
Yes, sir.
Get taken care of, will you?
Yes, sir.
All right, what do you want to say?
Judge, just, a young man who's got a lot of responsibilities. He went to Arkansas State University, played football there, and received about 80 credit hours. He's between, I think, 30 to 40 credit hours short of a degree. And he's got the responsibilities living with his fiance. He's got 3 children.
Did you graduate?
I got associates, so yeah, but I didn't get a bachelor's.
All right, go back and get your bachelor's. Where's he working in?
He's working in a warehouse right now in the Toledo area. That's why he moved down there, and he's had to depend on family members. And he's aware of what you said, Judge. And also with regard to Detroit, there's some amnesty programs where they don't get rid of the charges, but at least they get rid of the
Late fees.
they waive the late fees.
Right. Anything you want to tell me?
No, sir.
Stop doing this, will you please?
Yes, sir.
You're hurting yourself.
Yes, I am.
100 fines, 125 costs, 75 victim charge, $50 justice assessment, 350 or 60 days. Can you pay all that today? 350.
350.
No, sir. Can I? I'm actually paid on Thursday.
How much can you put down today?
Today.
Yes.
Judge,
Judge, can you put $40 down and then pay within a month?
I can do it ultimately. I'm there.
You can, are you sure?
No, there's no Friday. I can do it.
Okay.
Thank you. Make sure I do. I'm just right there.
I'm gonna give you, and we're not open on Friday. Okay? So I'm gonna let you pay by Monday, but you can pay it earlier if you want to. So you pay 40 today, the rest by Monday. The balance will be 310. That's June 20, hang on, let me finish. That's June 22nd. Somehow, some way you don't have the money on Monday, you call the court, we'll go on Zoom, I'll give you an extension. Do not ignore me like you've ignored these other courts and judges. You understand what I'm telling you?
Yes, sir.
Good. Okay. Did you have a question?
Yes, for the payment, would I have to come back here or will I be able to do it online?
You can do it online. They'll give you the information down there. There is a minor fee if you're not paying the whole thing in full. But since you have 40 now, you can go down the hall and pay that. And there will be no fee when you pay the balance on Monday, as long as you pay it in full. Do you understand that?
Yes, sir.
Okay, you're all set. If you want the information to pay online, they'll give it to you down the hall. Good luck.
Thank you.
Thanks a lot, Mr. Graziani. Did you speak to the prosecutor yet, counsel?
Real briefly, Your Honor, we're still waiting for my client to log in.
Time was it scheduled?
It was scheduled for, I believe, 8:40.
He's one of these guys, eh?
He's
an hour late. I hope you called him and told him to walk.
He just logged in, Judge.
He's an over the road driver and he's in Tennessee, and I think he mixed up the Eastern and Central time is what may have. Nope, and that's him right there.
He's pulling over, right? He knows he's not going to be driving, right?
He better be pulling over.
You need to pull over, Mr. Bashiga, right now. What is he doing? Does he think I'm going to wait for him? Mr. Bashiga, you need to pull over right now. I'm not going to wait much longer, okay? Who's he talking to, or is he singing, or what?
I think he's talking to us, but he's on mute.
Pull over, Mr. Bashiga, and then unmute. You got about 5 minutes. I don't get it. Telling you, Mr. Kelly, they're gonna be us doing these out on boats and country trips here before not too long. Do them by Zoom to accommodate people, and then they still manage to act like
I appreciate your.
For them to show up.
I appreciate your
Marquise
patience.
Calvin Hardman, 25M 549 574 A and B.
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Hardman. Mr. Hardman, please state your full name for the record. Marquise Hardman.
And now where in the world has Mr. Hardman been? Mr. Hardman, where you been? Working. Good. You got a lot of money to postpone that. Am I glad you said that? Where do you work?
One down in our. I was going to take care of all of this.
Trying to take care of it. You're about a year late. Does he stand mute, wait formal reading, counsel?
That's correct, Judge.
Not guilty, please enter. Mr. Hardman, do you make a habit of this, or are we the only court that you think you can ignore? Mr. Hardman, did you hear what I asked you, sir?
No, I'm not like that. It was, but for my job, I'm trying to like get everything cleared up.
Did you just walk in today?
Yes.
Well, that was nice of you. You want to go pre-try this for him?
Are they here today?
This is the state case.
State prosecutor's here?
Correct.
I'll do that.
$500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm entering a not guilty plea. He's got a ticket that's unpaid. I'll indicate he stands mute, waives reading. Mr. Hardman.
Sorry.
Go up in court. Okay? John, you can give this to Mr. Westmoreland. Thank you, Mr. Westmoreland.
Okay, I'm thank you. All right, thank you.
That's Tom and Jerry. That's back in my year, I think. All right. Hang on. Let's see here.
Well, Judge McNally, happy Tuesday to you, sir.
Hey, good morning to you. How you doing, Deputy?
Not too bad. I only have one scheduled for you today, Judge McNally. I don't know if your court is, as we normally say in the service, full to book as we are, but I have an Evelyn Cook for you. That's it.
Okay. What time is that scheduled, Lisa? Is the lawyer on Zoom? Do you know?
9:15.
Yeah,
That one's actually for Graziani. So if he can get on Zoom, we can take care of that one.
Can you convey to Mr. Graziani for him to get on Zoom and he can take care of talking to that gentleman, please? All right. Do I have Cortez Levon Martin here? 25B714039.
He's in a breakout room with the attorney.
Okay.
Do you want me to try to bring in Mr. Kelly's client again?
Sure. Is he pulled over yet?
I put him in the waiting room.
Mr. Bashiga, you got to unmute. Uh-oh. What case does he have again?
It's in our system with the last name of Clinton. Bashiga, Bowesia, Clinton.
They didn't bring that in, did they, Denise?
I haven't seen it yet.
I spoke with the prosecutor, Your Honor, real briefly, and they said they were waiting for our client to log in so they could give her the file.
Did you guys cover this or not, Mr. Kelly?
We hadn't had a chance to talk because they wanted our client here before I could speak with the prosecutor.
Good enough. So Mr. Kelly's ready to speak to you, so we'll put him in a breakout room. Thank you.
Thank you so much, Your Honor.
Mr. Bashiga, you have to learn how to unmute, okay?
Yes.
All right. Next time, don't be driving when I'm calling your case. We understand one another?
Yes, I'm so sorry for that.
Okay, good enough. Mr. Tio, good morning. I'm going to call your case. Cortez Laban Martin, Q Spy B 714039. Good morning, Mr. Tio. How are you?
Good morning, Judge. I'm good. Rushing to a jury trial downtown.
Okay, your appearance?
Deanne Patillo, PA 2378 on behalf of Mr. Martin. Mr. Martin, state your name for the court.
Cortez Martin.
All right, so we're going to adjourn the PCC to June 23rd and the exam till the 30th, right?
I thought, can we do the PCC on the 30th?
I'd rather not. I can't be here the 7th. I really don't want to go all the way to the 14th on this.
Okay, we can do that, Judge. I just have a jury trial in Romulus that day, but I can log on Zoom and take care of this.
What day? On the 23rd?
Yes.
So I can make it 8:20 for you that day.
Okay, that works, Your Honor.
And then we'll make the preliminary exam June 30th at 10. Sir, you have the right to a probable cause conference within 14 days of the date of the arraignment. Your lawyer needs time to review the discovery and properly prepare a defense. She's asking that I adjourn this case until the 23rd for the probable cause conference. If I do that, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. You understand that?
Yes.
You wish to waive that right?
Yes.
Anybody force you to do that?
No.
All right, we'll make the PCC June 23rd at 8:30, the exam at 10:30, Lisa, or 10 o'clock?
10:30.
10:30. Okay?
Thank you, Judge. You all have
a great day, Ms. Patillo. Good luck to you, sir. Bond's continued, and you'll have to be present on the 30th for the exam if it goes that far, okay?
Okay.
Thank you.
Thank you. Have a good day.
You too.
Thank you.
People against. Marquise Hardman. This is file number 25M549574A, and then he also has a B file for which we're going to have to conduct a show cause. Your appearance?
Attorney Corey Westmoreland, appearing on behalf of Mr. Hardman.
Sir, your name?
Marquise Hardman.
All right, so as I understand it, he's going to be pleading guilty to the charge of allowing an unlicensed driver to drive with the understanding that the no license will be dismissed, true?
That's correct, Judge.
And sir, do you understand that and agree to that?
Yes.
And you understand that possible penalties on this are up to 500 fines, 90 days jail, costs are all those. And that the judgment on the civil infraction charge of speeding, which you didn't show up for, will remain in full force and effect. Do you understand that?
Yeah.
And did you sign, read, and understand an advice or rights form here today?
Yes.
If you plead guilty, you're giving up all those rights and you're waiving your right to a trial of any kind. Do you understand that?
Yes.
All right. To the charge allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2018 Chevy that was being operated on June the 12th of 25 at 6:10 in the morning on I-75 southbound near Western Woodhead?
Yeah.
And you were unlicensed at the time, correct?
Yeah.
And you were operating that motor vehicle. Is that true? Nice and loud for me.
Yes.
Is that nice and loud?
Sorry. Yes.
Are you on probation or parole?
No.
Anybody in the world force you to plead guilty?
No.
Please accept it to that charge. I'm dismissing the original charge of no license. So he has to be sentenced on allowing an unlicensed driver to drive, for which he is now valid, and got the other judgment in effect. What would you like to say?
Yes, Your Honor. Mr. Hardman is apologetic. His birthday came, his license, he didn't renew his license, but he quickly did fix it. He is valid. He stands before you today. He has no prior criminal history. He's not on probation.
All right. Anything you'd like to say, sir?
Yes.
What?
Allow me to get this off.
100 fines, 70 costs, 75 victims' rights, $50 assessment, 295 or 60 days. He still owes how much, Lisa? Is it 248 on the other case, on the B file?
Yes, 248.
So you have 248 plus the 295, which should be 543. Do you have all that?
Yes.
You have it all to pay?
Yes.
All right, you pay your allowed and licensed driver to drive now in full. And you're gonna pay the other one. Lisa, I'm gonna reduce the balance form on the limited access to 200 from 248. Balance waived. And then once you pay that 200 plus your 295 to 495, we'll close the cases. Good luck. Don't ignore our court again, okay?
Yes, thank you.
Have a good day. You seem like a nice kid. Act like it, okay?
Yes.
All right,
He was
good.
nothing but respectful.
I can tell. He's a respectful kid. That's why I did what I did. Good luck.
Thank you, Dave.
Thank you.
Have a nice day.
You too. Mr. Graziani can you hear me?
I put him in a breakout room.
Oh, okay.
Miss Cook, can you join the breakout room?
You have to
It's on
join
your
the
screen.
breakout room, Ms. Cook. Oh, boy.
Cool.
John. I don't know what to do with this one.
Who you
The
have?
prosecutor handed it to me. It's in custody. She just brought it in.
I don't even know who that is.
I don't either. I don't. It's
Is it
not
for
on our-
Golden?
Yes.
It's not on the docket. He came in to do a amendment of bond conditions. He spoke with the prosecutor.
Oh,
Okay.
yes, I put it up, I guess.
Where is the defendant at least?
Is it not here?
I don't think so.
Where's Mr. Golden at?
We sent him to talk to the prosecutor.
She brought the file in.
She brought it in, she's ready, but I don't know where the defendant's at.
Do you know where Mr. Golden is? It says change tether radius. It's a felony.
They were out, you're in the hallway. Give me a second. Let me call that name down.
And I need the defense lawyer in here too.
I was given this file. I forget who gave it to me. Email gave it to me and just told me they wanted to change the radius, even though we have a PCC next week, which I kind of found was weird that we.
Well, I can't change anything if I don't have him in here.
What is it?
I can't change anything if he's left and where's his lawyer? I can't just change in bond conditions without his defense lawyer here.
I didn't post the defendant was out there. I never even talked to the defendant, but I had to run all the complaints when I found out that the address is no longer their address.
All right, well, let's get him in here and we'll go from there, okay?
I'll call them out.
Thank you. Are you, Golden?
Yes, sir.
Call in the prosecutor, will you? Brianna LeJohn, Jean Golden, 26B-713-794. Come on to the podium, please. Your name?
Brianna LeBron, Janae Golden.
Big Judge McNally.
I got a problem here. Wait a second. Did somebody tell you to come in today?
Yeah, I called yesterday.
Called who?
I called here, when I left.
Where's your lawyer?
I don't have one. I wasn't supposed to have court today. This was, an infraction. They told me I could call up here to change my address because.
Slow down.
I'm sorry, I was.
Slow down.
Judge, she just walked in this morning and it was my understanding that the do not enter address was incorrect. So we sent her to talk to the prosecutor.
Your name?
And good morning, Your Honor. Anthony Asmer on behalf of the people, PA 130.
All right. Can you try to explain to me what's going on?
Well, Judge, all I know is this case was up for PCC on the 23rd. I was brought the file and made aware of this address change. I had Laura call the complaining witness. Complaining witness states that they no longer live at this address. So I believe it was just amending the bond and the tether restricting her from going to this location, allowing her to go to this location because the complaining witness no longer lives there. I spoke briefly with the defendant asking where her attorney was.
Yeah. I don't feel comfortable proceeding here. I'm sorry, you're gonna have to wait until next week. I don't have your defense lawyer here. This is you got felony charges here.
No problem.
Ma'am, just wait, please. You're saying you called and somebody here told you to come in today?
Yes, I called the front desk, the lady at the desk. She said that she remembered me. She told me to come to open court. She said that she would put me in because there's not just a walk-in. And here I am. She told me to wait for the prosecutor and she gave her my file and that's all. The Wayne County told me that I could call up here to get the restriction changed, like from the area, because I live over there and the victim doesn't.
And Judge, I believe it was Heather that gave us the file.
Okay. Judge, I think we were under the impression that it was incorrect to begin with. Like that was her home and not his.
See,
like an incorrect address was given for the no contact.
I got it. Let me just check something here. Keon Majors, that is a male, correct?
Yeah.
So Judge Heston ordered you not to go back to 18040 Pine East Building 46 in Brownstown, right? And Judge Heston ordered you not to be within 2 miles of the victim, his residence or place of employment, right?
Yeah.
And you, counsel, had confirmed that the victim, Mr. Majors, no longer resides at 18040 Pine East Building 46?
That's correct, Your Honor. Laura did just call them. I was there during the call.
All right.
Yeah.
Okay, just give me 1 second, will you please?
Of course.
I just want to make sure we get this right. I see what happened, Lisa. It's fine. But next time you have to come with your lawyer, okay? I don't feel comfortable. This is still a felony and I don't feel comfortable with you walking in without a lawyer. So here's what I'm going to do. You have a bond of $30,000, 10% that you posted, correct?
Yes.
And I'm going to go ahead and I'm going to continue that bond. And here are your new conditions. No contact with Keon Majors. You're not to write him, phone him, see him, text him, email him, have anybody else do any of those things for you or on your behalf. You are not to possess firearms. You are not to possess dangerous weapons. You're not to have any contact, like I said, with the victim or prosecution witnesses except through your lawyer. You're required to obtain a tether. You're not to be within 2 miles of the victim, his residence, or place of employment. So I'm going to have us, and you went and got fingerprinted, correct?
Yes, I called up to first time. They said if I was an accident, when I got booked, they did take DNA and fingerprint. I have.
Just give me 1 second, but just let me double check, please. Offense date was June 9th. Okay, it is on here, so that's been taken care of. So we're gonna send an amended minimus to the tether unit, Lisa, that takes off those conditions for not being able to go back to 18040 Pine East Building 46 or within 2 miles of there. So we'll take that off. It's just going to read like I've just prepared. No contact with prosecution witnesses or the victim, no firearms, no weapons, no alcohol, marijuana, or illegal drugs. And then that's it. And we'll so send that over and we can give you a letter just to make sure that there's nothing goes wrong. Okay. So Lisa will take care of that. Go down the hall and talk to her. We'll see you next week. You have to show up next week. You understand that, right?
They told, it came on Zoom. It said it's on Zoom on the 23rd.
Correct. Yes. And then the 30th, you have to be in person. Okay?
Oh, wait, I don't know I didn't know I had court on the 30th. 30th, at what time?
They'll give you a new notice. You got 2 court dates here, June 23rd. If it doesn't go to the preliminary exam, then you wouldn't have to show up if you waived this. But I'm gonna let you talk to your lawyer. We're gonna give you 2 court dates right now, June 23rd and June 30th down the hall. Okay? Good luck. Thank you. All right. Bashtiga, Wawija, Clinton. 267-680-0000. All right, counsel, your appearance.
Brian Kelly on behalf of the defendant, Your Honor.
Mr. Clinton, your name?
Wija Clinton Bashiga.
All right, so he is charged with operating a commercial vehicle while license suspended, revoked, or denied. And does he waive formal reading and stand mute on that, counsel?
Yes, Your Honor.
I'm entering a not guilty plea. I'm going to give him $1,000 personal bond. You can leave state without consent of the court. So you're an over-the-road trucker, correct?
Yes.
Sorry? Is that true or not?
Can you repeat your question?
You drive from state to state, right?
Yes.
Okay, so I'm just looking for permission to do that. I'm giving you $1,000 personal bond. You have to appear in court as directed. You're not to violate a law. We'll give you a pretrial date. What do you want to do here, Lisa? The 30th? Is that good, counsel, with you?
June 30th at 8:45.
I believe it is, but let me double check, Your Honor.
Take your time.
That'll work. Thank you, Your Honor.
June 30th at 8:45 it is. But you have to be parked, sir. Okay? You have to be parked. You understand that, right?
Yes.
Okay, good luck. Thank you. Evelyn Valerie Cook.
Thank you, Your Honor. Have a good day.
222-705-215.
Good morning, Judge and staff. John Graziani, appearing on behalf of Evelyn Cook, Judge.
Ms. Cook, your name, ma'am?
Judge, it looks like we lost the jail.
Why is she still in custody? It looks like she posted her bond.
She did post a bond. That's what I was about to ask you, Judge, and I was asking, I want the release. She is a nurse's aide and she's taking care of a gentleman at the,
All right, let's get them back here somehow. Yeah, it looks like the bond was posted this morning.
yes, sir.
We'll get the person back, hopefully,
Okay, Judge.
and I'll let you know.
Okay, I'll just, either way, I'll get it wrong.
You have another case somewhere you can deal with now, or?
I believe, John will talk to one, but in the meantime,
I don't have it.
okay, nothing else. I'll be back there in a little and I'll
Good enough.
wait for, thank you, Judge.
Thank you. Good morning. All right.
Judge, we have an exam, Michael Wilson, also wants to ask for an adjournment. Do you want me to write something up for that, or do we?
No, we'll just do it online. Where's your client?
He's gonna be on Zoom, Judge.
Why is he on Zoom?
He sent me pictures. He got a flat tire and he moved from Ohio.
London, the case. He got a flat tire.
I have pictures.
I believe you. I'll call the case. We go from people against Michael Andrew Felsky, 26W703-474FY.
Good morning, Your Honor. Counsel, as non-applicable PA 100.
And Leanna Belcher, P80177, on behalf of my client, who should be logging on to Zoom, and I'm sure if he's logged on. Yeah, Your Honor.
What?
He's not logged in yet, Judge.
Okay. You want to call him?
Yes, Judge.
We'll go off the record. You can go ahead and call him. How you doing, Ms. Esmer?
How are you?
Not too bad. Great.
Ready for Juneteenth? Is everyone on Friday up here?
Yeah, Friday off.
Not you?
That's because you're a high priced lawyer.
Yeah, fortunate. Do you have any plans for the weekend?
I'm going.
He's here, Judge.
Okay. Michael Andrew Felsky, 26W703-474. Mr. Felsky, your name?
Michael Felsky.
Good morning again, Your Honor. Leanna Belcher, P80177, on behalf of Mr. Felsky.
All right. Where are you, Mr. Felsky?
I'm at home because last night when I was coming up for court after work, my tire on my work vehicle blew and I had to have it towed.
So we can adjourn it a week.
Your Honor, the problem with the week is I started a 3-week-long trial in the criminal justice complex in front of Judge Van Houten. And then the week of July 13th, I have a pre-planned vacation. So I'm not available until the end of July.
Oh my God. Why can't you get it fixed and drive up here now?
I don't have the money to to fix the tire right now, and it's a work vehicle, so I gotta wait for work to handle it.
Just gonna go.
I do anticipate it going, Your Honor. I was going to ask for an adjournment because my understanding and speaking of this as Morrow, the people intend to increase the charges when I hold from an RNO to an RNO causing injury for an officer Lyles from Brownstown. I've been requesting additional discovery materials and I can place all of that on the record. The majority of them were sent to me last night at almost 9 o'clock. Body worn camera that I haven't had time to review, and missing medical records, which I believe we're going to ask for a protective order from Your Honor to sign so I can get those, as well as a number of reports. I can go through the whole list of things that were not included that I've been working with the prosecutor's office to try to get prior to holding the exam. I would need time to review those materials. I certainly think they're relevant, especially if the people are going to try to increase the charge to an RNO causing injury, which has an element that medical attention is needed.
I got it. So you intend to do that? Are you insisting that the exam be held?
They are not insisting, Your Honor. My client wishes to hold the exam. And my understanding is if he's holding, the people are going to seek to increase to that charge.
And that's correct, Your Honor. Regarding discovery, almost everything has been sent. I am in possession of medical records and I am currently typing up a protective order for this court to sign so that I can get these over to Attorney Belcher.
Boy, this is not good. So you're saying you can't do it until the third week of July?
Your Honor, I wish that I could do it sooner. However, I'm starting at 9 complaining
No,
witness.
but is that what you're saying?
Correct. The first Tuesday that I'm available, Your Honor, is July 21st. I can clear my schedule and make sure that I'm here.
I don't know why you needed to take a work vehicle. I have a good mind to issue a warrant for your arrest. You know that?
I don't
didn't say you had to drive a work vehicle. I don't care how you get here. You needed to have somebody drive you here. This is a preliminary exam. I can't, this is going 2 months now. Where are you, in Sandusky?
Yes, sir.
Remind me how far that is.
It's an hour and 45 minutes to
Good. Get your tail here. We're going to do it this afternoon. Any reason you can't do it this afternoon?
Your Honor, I'm subpoenaed to testify in a preliminary examination down the hall at 1:30, where I am a complaining witness or a witness.
That's correct, Your Honor.
I could be in the building.
Well, that's fine. That's fine. You figure out a way to get here, young man. We're going to do this. I'm going to set it for 1:30. I will take it after. Oh, you don't have the discovery.
That's, Judge, I have to.
Why did you guys wait to give them the discovery so late? Why did it take so long? I mean, this case been going on since May 22nd.
Your Honor, if I may, I don't believe Ms. Asmara was aware of what was missing. So what happened was we appeared for the probable cause conference. At that time, I only had paper. Ms. Asmara sent me everything in evidence.com. When I started reviewing everything in evidence.com, there were 14 different video files. There are 3 different policing agencies involved in this case: Woodhaven, Brownstown, and Trenton. I only had 14 videos from Woodhaven. Last week, I did send an email to Ms. Asmara identifying all of the things that were missing: the 911 call, additional body worn camera from the 2 other agencies, use of force reports, medical records. My understanding is I sent that email towards the middle or end of last week. Ms. Asmara made contact with the officer in charge yesterday. Some of the items were sent. However, they again only sent items for Woodhaven because the officer in charge is.
Are you confident that that other case is going to take 3 weeks?
I sure hope not. I don't even want to try the case, Your Honor.
Okay, well, I'm just trying to figure out if I can't do it a little earlier.
Judge.
Do we have somebody sitting for me on the 7th, Lisa? Just, I get it. Just give me 1 second. I just want to ask.
No, Judge Heston will be handling all the PCCs.
And your trial starts,
Next Monday,
which is the 22nd.
27th. And we go Monday to Thursday. We do not have Fridays.
So 21st, 28th. All right, here's what I'll do. I'll adjourn the PCC to the 7th, okay? if you're still in trial, you guys submit a stip in order to adjourn and I'll sign it. All right? We'll adjourn the PCC to July the 7th at what time, Lisa? 9:30?
Yes, 9:30.
Make it or note adjourn if defense attorney's still in trial. You'll just have to submit a stip in order, okay?
That's your preliminary exam.
No, I'm not gonna. It sounds like she's still gonna be in trial then, right?
I anticipate.
So that's what I'll do. I'll adjourn the PCC. Sir, you have the right to a probable cause conference within 14 days of the date of the arraignment.
Judge has previously been waived on.
Has it?
Yes.
All right, so we're gonna set it for July 7th at 9:30. And then July 21, I'll do the exam, Lisa, since you're not available the week before, right?
That is correct. The
PCC will be July 21 at 10 o'clock, Lisa, or will you want a different time?
For the exam,
Yeah,
10:30.
10:30.
yes, Judge.
Okay, sir, I'm gonna tell you, you have to make sure you're here. If you don't, I don't care what the excuse, you should have made arrangements to get here today anyways. If you don't get here, I'm gonna issue a warrant for your arrest. Do we understand one another?
Do I need to be there by 1:30 today?
Not coming today. You're having to come here by Zoom on July 7th at 9:30 unless you hear from your lawyer, and you need to appear in person for the exam on July 21 at 10:30. Do you understand that?
Yes, Your Honor.
So I don't care if you have to get a hotel overnight on the 20th to make sure you're here, but I'm telling you, you have to be here on the 21st. I will not adjourn any of these dates except as I already stated. Okay?
Thank you.
Good enough. Have a good day. Thank you.
Thank you, Judge.
Where is Ms. Cook at? Do we have that one ready yet, Lisa, or did she not? Did we lose them completely again?
Yes, she has not logged back on yet.
I feel bad about this because if she posted the bond, I don't know why she's still in custody.
Judge, I think she has other pending cases. I looked online and they have other cases listed with court dates of June 24th.
Your Honor, if I may interject, Ms. Cook did not indicate she had other cases. I wasn't aware of any additional cases, sir.
Right. Are you going to call over to the jail, Lisa, and see if they can't put her back in?
Yeah, I'll try to call over there.
So
Thank
we'll
you.
do that, John, Mr. Graziani. And
Thank you, sir.
go from there, okay?
Thank you.
And sir, what is your name on the Samsung?
Jeffrey Vance.
Jeffrey what?
Vance, VANCE.
That's Mr. Mays's case. We're just waiting for him to log on.
Okay. What is that? Is that a preliminary exam?
Yeah, PCC.
And I have the exam up next week on that, right, Lisa?
Yes. Okay, Judge, they're going to work on getting Miss Cook back on right now.
Perfect. I'll wait right here. They're working on it, Mr. Graziani, so they should be bringing her in a couple minutes, I would assume.
Thank you. Thank you very much.
All right. Oh. Hmm. Should have.
Alleged victim pled to a larceny, which would absolve Ms. Cook of any liability. And here's where we're at right now, Judge.
How in the world is she going to have you come in here and tell me she thought this case was resolved?
Judge, I get it, but this is what she thought. She is a caregiver. She is a nurse's aide through the state of Michigan for the past 24 years. She's been locked up for about a week right now in the jail. The bond has been posted. As you could tell, it was a 10% bond. The bond was posted. I'm just asking right now for her to be released. And if you have concerns about her not showing up, even though I don't like the tether thing, put her on the tether, sir.
Ma'am.
Yeah, yes, Judge.
Please let the judge speak.
Please don't tell your lawyer you thought that the case was resolved. It insults my intelligence. It really, truly insults my intelligence.
Yes, Your
Now,
Honor.
I don't want to hear this nonsense anymore. Don't tell your lawyer you thought the case was resolved when you knew the case wasn't resolved. We've been going round and round on this. You were in here. I arraigned you in September of 25, and you posted a 4,010% bond. So please save the lies for some other judge in some other court on some other case, because I don't want to hear them anymore. Do we understand each other fully and completely?
Yes, we do, Judge.
Then don't tell your lawyer lies, knowing that he's going to repeat them to me. Do we understand one another?
Yes, we do.
Good. I shouldn't have to tell you this unless you're 8. Now, that being said, why is she still in there if she posted the bond, Deputy? Can you tell me your name, sir, and tell me why she's still in custody?
How you doing, Your Honor? This is Barbara Senior. From what I understand, she's probably in here because she maybe have another warrant or something that popped up. So they had to go through court today, and now she should be able to be released. Whatever case she had going on today, they usually hold it until she goes through court and finishes that, and then she should be released today. Unless there's any holes somewhere.
I understand. So what do you want me to do? Adjourn this again?
Judge, I need this matter adjourned because I'm not in a position to really talk with her at this time. I feel.
Okay, fair enough. Do you live in Wyandotte still, ma'am, on St.
Yes.
John's?
Yes.
Now, I'm going to tell you something. I'm adjourning this for 1 week, and you are going to appear in person.
Correct.
Do we understand one another?
Yes, we understand one another.
I have a good mind to raise your bond to a amount that you would never be able to post, because you have missed court date after court date after court date on this. And I'm not going to play games with you. Do we understand one another?
Correct, we do understand one another.
And we understand that we're not going to lie through our lawyer by Zoom, in person, or otherwise. We understand that, right?
We correctly understand that, yes.
Because if I didn't think you understood that, I would set a bond that you're going to have to hire a heart surgeon to post the bond for you. And you are going to be sitting in custody until the cows come home. Do we understand one another?
We understand one another,
If you
Judge.
do not show up next week, I will write this down. 100,000 cash or surety, and I will call up the Wyandotte Chief of Police and ask them to have you arrested. Do we understand one another?
We do, Judge. Yes.
I don't get the whole lack of respect thing going on there. My God. I just don't understand it anymore. June 23rd, you will be in person and you will be here at 9 o'clock in the morning. Do we understand one another?
We do understand one another. Yes, Judge.
Now stop playing games with me. Do we understand one another?
Yes, we do, Judge.
Good.
Judge, for the record, Ms. Cook, once you get out, you can call me. The number is area code 734-246-0000. We can resolve this matter, but you have to call me, ma'am, please.
Thank you, Deputy, for your time.
No
Good
problem,
luck
Your
to
Honor.
you, Ms. Cook. I will treat you fairly unless you don't show up next week, in
I'll
which
be
case I
there.
will write down 100,000 cash assured. You
I will be
understand?
there. Yes,
Good
sir.
luck.
Thanks, Judge.
Thank you.
Thank you, Your Honor.
Thank you, Deputy. Wait, I thought I'd see the day before I see him. Have a great day.
Judge,
Thank you. Are you done?
I'm going to be asking.
Yeah, we'll talk to Lisa. I think.
Yeah, that's fine.
That's,
Thank you.
thanks a lot.
How's everything going?
Great. Great.
How's the golf game?
My golf game is horrible. I should be doing okay. See you.
Boxing, right?
Right.
Attorney and the state's attorney, and I want. And we were here with Mr. Adams, your attorney and the state's attorney, and once again, for the record, you were charged with a second-degree felony of assault on a peace officer. My striking the officer with a purse, it was signed. And this indictment alleges a second-degree felony again, which means you are facing up to 20 years in prison. And it's not a wise idea to strike a police officer who's doing their job. I'm going to reset this for an announcement. And please get a resetting. Anything else we state?
Nothing further from the state, Judge.
Okay. Silverito Hippolito. It's almost rhymes. What's your name that rhymes?
It does.
Silverito Hippolito.
And he is here.
He certainly is. That's you, sir?
Yes.
Okay. And Mr. Adams is your attorney. Oh. Are you still at 13034?
I should know.
Okay, I need your new address. That was Knollcrest. You've moved. All right, we got to keep up with you here.
because you were just indicted in April, they would have used your address that you gave them in April. So you moved recently?
Yeah, because I'm working here in Barber, project for Beckle. So I just,
That's where you're living now?
I'm studying, sir.
Okay. Give me the address then.
25 City Circle Porch, Texas.
25 what?
C.
C is in Charles?
C is in Charlie, but you see Circle Porch, Texas. I'm renting a room there.
Is that a room number?
It's a house, but I was renting a room.
And what's the zip there?
Yeah.
Zip set?
776
All right. Okay. You were charged here with a third-degree felony of evading arrest or detention with a motor vehicle on or about February 14th, 2026. That would have been Valentine's Day, I think. But it doesn't end there. We, all defendants charged with criminal cases, the factoring that goes in on determining what is the punishment is based upon the crime and circumstances of the case and the criminal history. And I don't have to tell you, you've got 2 convictions here in October of 2022, felony convictions of assault on family members out of the 185th District Court of Harris County, Texas. So what that means is if you were found guilty of this first crime, and if these 2 other allegations are indeed proven true, the third-degree felony bumps up to a second-degree felony punishment because you get punished more for subsequent crimes. So you could be looking at up to 20 years in prison on this case. So it's serious. So you want to make sure you heed the advice your attorney gives you. And it's going to be set on the announcement document.
Yes, sir.
Oh, okay. And what else? Do we need anything else to do in this case?
That's it.
State, anything to sound in on?
Nothing further from the state.
Okay, please get a resetting. Ricardo Kelly.
He's here. There you go.
It's an announcement, though.
Yes, Judge. On his case,
Ricardo Kelly.
Ricardo Kelly, yes, sir.
And state jail felonies.
Right
here. This seems like that's fixable, but
yeah,
I don't know.
The way I think it can be fixed, Judge, is that it involves the Avis rental car, and I think in the value they had the car is $24,282. To my understanding, what might be a fix with district attorney's office is them getting that car back. I think that's well. I don't do it.
You're correct.
Right. It doesn't.
Oh, well,
It's so
they don't. Where's the car?
well. Pete,
It was in his position, but it was it? Oh my God!
This is the one that's on.
Oh, it was a rental, right?
if he's supposed to get called.
This was a rental.
Correct.
October 30th, 31st, going on 3 years ago. It's still being rented.
No. Nobody's had this. I don't know.
Well, they don't have the car back.
I don't believe they have a car back.
What the heck is that all about? Where'd the car go?
Okay, the thing is, I put the car rented for someone, and they did bad with it.
That's your problem too.
Yeah, but I'm not going to say that if I didn't do nothing with the car.
No. You rented it from.
Yeah, that's my fault for putting my name on it.
Yeah, well, that's your responsibility when you write. That's a deal, a contract you made. But you're subject to being responsible for it. You just don't then subcontract them away. That's your problem. That's why they indicted you.
I'm not saying
the other guy may be in trouble too, but this was your response. When you sign your deal, you make a deal, you make a contract.
Right.
And that means under the law, you're held accountable.
And I believe
that's a lot of money.
He was get the car back from the person who actually took possession of the car.
When would that happen? We're talking 3 years ago. The loss of value is, I mean, he's got all kinds of problems here. There's no way it's the same value. It's lost its value over 3 years of use. But I don't think they're going to be happy about it. I mean, it's generally, oh, it's Avis. Well, they're not letting that slide.
But I didn't want to put it on trial because the reason why I didn't want to do that was.
No, it's 3 years old. Langston, we got to move it one way or the other now. Where are we going to go? It's 3 years old. This is stalled. It's getting aged. It's too old. It's fish or gut bait right now. What are we going to do?
There's no idea.
You're mumbling. I can't hear you, sir.
I'll take the 5 years probation to get this out.
He said he'll take.
Where's the car?
I don't know. The other person did something with the car. That's what I'm saying.
Well, you're going to have to do something though to help the police and Avis get that thing. And that's going to be a condition. If you're on probation, that's a condition of your probation that you 100% cooperate with the authorities to get that darn car back.
And that's fine.
Okay. Oh, well, it's the right thing.
1 week to limit on this one, and I'll work because I think it's not going to be a trial. I'm positive to talk with him about it, and then I can get with y'all.
Okay, is 1 week good for everybody?
Yes,
We'll reset this 1 week and see if we can move it next week with and just kind of get all the plans in order of what he's going to need to do to cooperate as a term of probation. I want that because he's got a responsibility to help out and get that, do what he can to get the vehicle back. And then that person, do you even know where that person is?
Yes. I'm in contact with the person trying to keep them to come.
Well, what's the problem? Well, it's been 3 years.
Something shady about it. That's what I'm saying.
Oh, you think? Are they a friend of yours?
It's a friend of mine.
What kind of friend is that? You're stuck. You stuck.
And that's why I'm trying to get those good there.
I wouldn't be.
My name.
You still a friend?
No.
That's not the definition of a friend. You look at the dictionary. All right, get a resetting 1 week.
Just hold it. We'll make it out.
Matthew Sharp. Yeah. Matthew Sharp once, twice, 3 times Corey Crenshaw.
Oh.
What do Okay, I'm looking at the mail under this setting. It says communication issues.
Judge, I received a phone call from the victim's dad.
Form of communication.
Yes. The issue with the communication is that the defendant's parent or parents have reached out to the victim's stepdad asking for a meeting of lunch or dinner to discuss this case.
No.
And I would like him to be admonished that the defendant, he himself cannot contact them, and I'm asking that he not, and I can't prove that he had his family contact them, but that they can't contact them and know that victim's family does not want to be contacted.
Don't do that. Nor anyone on your band.
Yeah, they're co-grandparents, Judge. So let me get looking right. So there's a grandchild. So the grandfather contacted the other grandparents on the maternal side to discuss the child.
Just don't communicate about this case because it can be perceived as trying to influence this case. Okay, what are we doing on this though? It's set for trial?
Yes.
Because it's over a year old.
It's
set for trial.
It's coming up soon. Yeah.
All right, okay.
And Judge, I understand that they are co-grandparents and they may talk about the grandchild. My issue is them calling and saying, can we talk about the case? That should not happen. I'm not saying they can't talk about the grandchild.
Okay, so get ready for trial in July. David Bates. 26 CO 367. What are you doing today?
I'm going to ask for 4 weeks and probably be disposed of that.
You were David Wayne Bay, and if you're here with me, do for your attorney, I love. Whoa, boy. We got a long indictment here, don't we? The first paragraph alleges that you committed the third-degree felony of failing to comply with sex offender registration requirements. You understand? That's a third-degree felony, which carries with it up to 10 years in prison. But if it were on that, paragraph 2 goes on to allege that in 2008, so I think you're doing math, you're looking at what?
Got to.
Yeah, 18 years. In 2008, you were convicted of the third-degree felony of failing to register as a sex offender. After that conviction became final, you committed the felony offense of failing to register as a sex offender, and were finally convicted of that third-degree felony in May of 2014. After that conviction was final, No, I'm sorry. You were convicted in May of 2014 of 2 offenses of failing to register as a sex offender out of Stevenson County, Illinois. But the deed is done here. You've got that prior conviction in 2008. That's one. Then you got the 2 convictions thereafter in 2014 there. And now this third one. So you're looking at 25 to life. Okay, well, those would always cause me to at least have severe indigestion. So this has to be dealt with in a responsible way. What are we doing?
We've got an offer on the table that it's probably going to be acceptable. Give me 4 weeks and I think it will get disposed of.
Why do you need 4 weeks?
Because the court's going to be down 1 week and I'm going to be out another week.
Why can't we do it today? Here's what I'm looking at. Here's the problem. I look at the caption. He's a transient. Well, what happens? Really? What do I have to ensure he's going to be here in 4 weeks?
He's on bond. He's on bond. He showed up
today, but it wasn't.
My sister will be bringing.
I'm sorry, sir.
My sister.
What about your sister?
She's got to bring you to court.
But it's not her responsibility to get here. It's yours.
I have to walk. That's the only thing.
What's the plan?
We have an offer.
What is it? Have you talked to him about it? And
yes, but he and I just met today.
Okay,
looks like Mr. Ham made an offer of 10 years prison time.
Yes.
What was the last sentence in 2014?
I can't.
No, he wants to know what
did you get?
What did you get?
Stevenson County,
Did you get prison?
you were convicted of failing to register. What was your sentence?
2 years.
2 years in prison.
Well, what was your sentence in 2008 for the first time you failed it? 2? Really? That's the best they do, huh? Well, that's kind of a insult on the importance of the whole crime. Failing to register has high levels of importance, and they're just minimizing it every time for subsequent crimes. That's odd.
And I'm good for a whole year right now.
I'm sorry, sir.
I'm good for a whole year.
Sir, you're supposed to be good forever. Okay. That's why you're here on this. Okay. Is 3 weeks good?
I think 4 weeks is the first one I'm going to be available. But I'll be here and I think we'll get it disposed of at that time.
So what's the offer?
10.
And
do you understand that?
Yes, sir. And I would take it. I would do 10 years without parole.
What's that say? Do we need any other conditions of bond?
Judge, since he's a transient, I don't know if he can afford to have a GPS monitor on him.
puts us in a position where he's in control.
I'll be here when I come back to court.
Sir, if I had $1 every time people made a promise they didn't keep when they were standing where you were, I'd probably be like that guy in the president's office.
Yeah.
Let's all make a leap of faith.
Okay. Stand there, should be.
Good luck to us all. If you fail, of course, to be here, you know, all you've done is compound the problem, because it would be another felony offense, which would make another 25 to life crime, which would put you in a position where there's no turning back. You know what I mean?
Yes, sir.
Because that would be 2 life sentences, which
I don't want.
you don't want.
No.
No one wants. Alicia Simeon?
Judge, all the name, no response.
Alicia Simeon. Is that you? Are you? That's you? Oh, come on. 25 CR 1739. On this one, what are we doing on that? You had a chance.
I spoke to her on the telephone, but again, there was no answer in the courtroom prior to court.
Okay.
If you'll hold on to it, we can maybe dispose of it this morning.
You're Alicia Simeon? Okay.
You
Are you aware that you're charged with this 3rd-degree felony of theft, which carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed? Do you understand?
Yes, sir.
Where's the truck? Was it returned?
Yes.
Okay, you don't have it. They got it. The people who own it.
Yes, sir.
Okay, that's the most important thing. All right.
If you just hold it,
what y'all are going to do. Okay.
Yeah, we're going to see out there. I'm going to share a visit with you. Don't leave the store.
Herbert Smith, please.
Herbert, call that name, no response.
So, are you Herbert?
I've been out there. I've been out there for an hour every 10 minutes.
You getting them in?
Do a better job than me.
He must have been whispering.
Okay, 26 CR 526 is called the State of Texas versus Herbert August Smith. That's you, sir?
Yes.
And you're here with your attorney, Mr. Dusler, and the state's attorney. This is a 3rd-degree driving while intoxicated, and we get a lot of these, where if you have 2 or more DWI convictions, the 3rd one is always a felony offense. So you're looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 if indeed you're guilty of this crime. Hold on, let me look at this, sir. You shouldn't have that brandy in your pockets, huh?
It's
Okay, 0.206. All right, well, that's 2.5 times the legal limit, so that's not good. At 5:30 in the morning. First test was 0.209. Second one was 0.206, so you were coming down, but not fast enough. All right, what are we doing?
I've never met you. You've never talked to him? No, sir. That he'll just have a seat here. I'll come back to him and see what we can do.
Okay. All right.
Don't leave. Just stand forward. Let's finish up here.
David Stevens.
Yeah, I had no response as a man standing up. Judge, at 1 minute until 9, I was out calling names and none of them speak.
I'm not having any trouble, Don. I don't know what your trouble
Well,
is.
I guess they're just scary.
They're all showing up for me.
I've never spoken with him either.
Are you David Lee Stevens?
Yes.
I like your last name. One of us is misspelling it. Nonetheless, seriously, though, you were charged here with the 2nd-degree felony of aggravated assault with a deadly weapon, namely a knife. And that doesn't end there because the indictment states that you were convicted in 2010 in Sutton County, Texas. I'm not aware of Sutton County. I'm not familiar with that. Is that up near where?
Texas. Going toward El Paso.
Okay, it's west. What's the cap? What's the county seat of Sutton County? Yeah,
Sonora.
Sonora.
Yeah,
that's way out there.
Yes, sir.
Okay, it states you were finally convicted of illegal possession of a controlled substance, a third-degree felony in 2010 out of the 112th District Court of Sutton County. So what this means, it's not good. Your second-degree felony in paragraph 1, if you're found guilty of that, it can be enhanced or increased because of the previous third-degree felony out of Sutton County, if that's accurate. So if all of this is proven true, you were looking at a first-degree felony of no less than 5 nor more than 99 years confinement or life imprisonment, and a fine up to $10,000. So that is what you're facing here. The victim in this case, do you have any connection with this victim right now? Contact? Keisha?
Yes, sir.
You're not supposed to.
I brought her to court so she could sign and let her know that it was untrue.
What was untrue?
The whole indictment.
Did she lie?
Yes.
Well, that's a crime, isn't it?
Wow.
How many people are going to get in trouble on this? I don't like that. That's not the way the game, it's not a game that's played. State, she's the prosecutor. I know the way she thinks about this stuff. Lying doesn't get you out of trouble. Get you in trouble. What's his bond? You're not supposed to have any contact with people who are the victims, especially and changing stories. It isn't the way. I know. Isn't the way it's supposed to be. Well, no, you've had contact because you know too much about the plan that's being hatched to try to absolve you of responsibility. The law is not a gun. The law, it's about fairness and justice. I'm sorry?
This bond is $75,000.
Who posted that?
I did.
Where'd you get $75,000?
I worked on.
Okay, well, it's doubled to $150,000 now. Threatened to kill her with a knife, holding the knife in the hair. I'm sorry. When I'm speaking, you can't speak because the lady can't take everything. But this is what the lady said, the victim. You said, I'm going to effing kill you. Blood was observed throughout the house. A weapon was located. The victim stated the threat was taking place. She tried to gain control of the knife, cut her finger in the process. They located you, detained you. Y'all had been in a dating relationship for 5 years, 2 children. This isn't role modeling, for children. This isn't good role modeling for children. No, I'm still working on the probable cause affidavit. It's lengthy and detailed. Due to the nature of this call and the partnership, both were in agreement of the assault was, I don't understand what that word is. The assault was a result of family violence. The victim states she believed that you were capable of your threats and that he placed her in fear of imminent death. You were thus arrested, placed in the back of the patrolled vehicle and transported. If the affiant believes if you and the victim were to be left alone, further family violence would ensue. That's why we try to work things to have no contact until we can resolve this. The defendant is charged with aggravated assault with a deadly weapon, a second-degree felony. Okay. Condition of all bonds or don't have contact with the victim unless I authorize it. And I didn't. Here's the remarks of the magistrate when your bond was set. Remarks: no contact of any kind with the victim, Lakeisha Williams. Okay. It's $150,000 plus you have to have a GPS device. Plus you will stay in home confinement at someone else's location other than the victim until this can be sorted out. Next time there won't be a bond. That's y'all figure that out. Those are the court's orders. You're taken into custody. You don't make the rules. The law makes the rules. And this is act of violence. This is very serious. All right, Jeffrey Dorsey. Ryan. Hey, Ryan. There you go. That's okay. I know you don't want to be after that one.
Well, yeah, I want to ask for a reset.
That's a frightening thing there.
It's not all.
You really want it? It's scary. It's scary. Okay, Jeffrey Dorsey.
Yeah.
Mr. Dorsey, where are you? No answer in the courtroom. I asked a bailiff to call into the hall for Jeffrey Dorsey, please. Guns. Come on in here. This is where the action is, sir. You got to be in here at 9. Not out there. This is where the court is, not outside. All right. Judge, you were charged, as you know, with the third-degree felony of deadly conduct, which carries with it up to 10 years in prison. And as you know, Mr. Dorsey is your time. Go ahead.
We're asking just for a regular reset.
There's at least regular in this room.
Okay. What are you asking for? 4 weeks.
Okay.
Thank you, Chair.
No, that's pretty regular.
Pretty regular. Thank you.
That's a regular. So it's for an announcement?
Yes, Judge.
Get a resetting. Thank you. We don't have to take up anything else, right? Stay? Nothing? Okay. Brendan Hardy.
I believe that's today.
Why is that? Is tomorrow a better day than today?
It's a long story, Judge.
It's a long story. Anybody know the way that story ends?
I mean,
I just want to know how it ends.
it ends with us having hearing tomorrow.
So we don't live happily ever after.
That's to be determined.
Hey, are you pulling Ryan's others? Because he's got a Brendan Hardy,
That's the one that's tomorrow.
Carrie LaBelle. Carrie LaBelle,
I mean, that's all that.
2 cases.
Yeah.
Carrie
They'll
LaBelle.
have to come back.
Hey, Ryan, let me go to you. Bryson Granger. That's what they said.
At least he's working.
That's great. Oh boy. April 19th was not a good day last week. That's even over a year ago. Well, this thing was filed in December. We're going to do it.
Keep him on probation.
Are we having a hearing on it, or is it going to be agreed? What do y'all had?
There is no agreement to keep him on probation, Judge. There is a state jail offer.
It's over 6 months old. Nobody's said it. Nobody's talked. Here's what we do. You set it for a hearing. Can y'all be ready in 2 weeks?
Yes, sir.
All right. It's a hearing. I'll make the decision. No deal. Daniel Rodriguez. Daniel Rodriguez. Right. Daniel Rodriguez.
Sir, I'm ready.
No. Don't get ready. 2 weeks. Daniel?
Yes, sir.
What's he going to, on this one? This is a state jail felony, right? That carries with it up to 2 years in the state jail. I don't see any criminal history, so it's, yeah, everybody makes mistakes. How you deal with your mistakes is the test. What are we going to do? This one is February of this year. It's indicted.
Now,
It is. It is. No, this isn't an NTR. The other one was. This is a new case.
I get an offer. I'll see if he wants to do it. If not, I'll see if he can change it. So you can
Hold on.
They're holding for a second. No, I talked to me.
Hey, this probable cause affidavit needs to be.
I don't like to get all done.
I know.
Already there.
I mean, this one, this could be a mistake going one direction versus the other. That's all.
Well, I'll talk to him. Yeah, like I said, I'll see if we talk.
He's up your right front. Right front. Okay. Walk right there. Get up again. This is flat right here. Don't roll it, okay? It's okay. Flat down. Yeah. Yeah. Yes, ma'am.
Carry it. Or what?
You can, sorry, I'm gonna.
Where's she? Come follow it. Seems like a nice life. Credit card?
Yes.
Yeah. We speak some or what? Okay, 26 CR. Let's see what we have.
Yeah.
26 CR 253 state jail felony. Credit or debit card abuse. I don't see any cars there. 26 CR 254 state jail felony of theft. Both state jail felonies carry with it up to 2 years in the state jail. But these without prior criminal histories, these are always fixable.
We agree, Judge.
It was indicted in February.
So we just asked for some additional time, maybe 6 weeks, Judge.
Is 4 good?
4 is fine, but I realized when I was saying 4 earlier that I'm gonna be out of the country in 4 days. So those things could be.
Don't tell me. I mean,
you guess.
Do I know? There's only 204 countries now. I can take a while.
Starts with a U.N.
You're not Iran. You're not solving that.
Yeah, the boots on the ground. They're going to put me in just tell me. That should be
well. Let's just say we spent a lot of great time in Italy.
Yeah, I think that's where we might go. So.
Okay.
All right. Thank you.
Did you say 6?
6, please.
Okay. Is this one of these things that might be disposed of by, is there a loss here that needs to be paid back?
We're working, Judge.
Okay.
That's part
so
of the decision.
6 weeks. Yep. Come back and let's move this thing one way or the other. Thank you.
Thank you. Ma'am, can you put my time right there? So. Right here. That's a thing. I'll stop playing.
And this is
I have it.
Button red, yeah.
We walk around.
Don, you ready?
I'm ready on Alicia Simeon.
Alicia Simeon, please. Forward.
Actually, the state is anything.
Thank you, Mr. President.
Are you still, what'd you say you were doing on Daniel Rodriguez?
I'm parking this,
Okay.
I think I can do the problem. On. Well, I really actually
All right, now we call 25 CR 1739, the state of Texas versus Alicia Simeon, present with Mr. Ducey, your attorney and the state's attorney. The defendant gave a formal reading of this indictment and the arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about September 17th, 2024 in Jefferson County, Texas, you committed the third-degree felony of theft involving a Ford automobile. Do you understand what you're charged with?
Yes.
If convicted of a third-degree felony, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can also be assessed. Do you understand that?
Yes.
Yeah. I'm looking at an agreement that has been prepared by the parties, which state you would be pleading guilty and placed in standby. Passed right out. You'd be placed on deferred or unadjudicated probation, which can be up to 10 years in length. So you don't have the most importantly be ordered to pay restitution. What is the was the truck ever returned?
I don't.
It says the truck was recovered in the 4100 block of Maida.
Yes, I don't believe there is restitution.
I don't.
Has to be.
That's why I put to be determined that if.
I thought there's gotta be.
If the real agency is asking for something to find a.
See, she rented it in July. And then it wasn't recovered until the following August 18th, with 5 weeks later. She was supposed to return it. She extended the rental and continued to pay the extensions until July 23rd. Okay, so it would be, according to this, a period of time, July 23rd through August 18th.
Yes.
Usage that was, so it'll have, we'll do a post sentence report and determine what the restitution will be, if any. And there would be terms and conditions of probation, which are normal and customary for this. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead in this charge, ma'am? Guilty or not guilty?
Guilty.
I'm sorry. Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked here as State Exhibit 1. Did you sign this document? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. What you've been charged with the indictment's been read to you. You were guilty to find charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the apparent confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
If nothing further, I will follow this agreement and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm not going to do that. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation. If you fail, your probation can then be revoked. You can be found guilty and sentenced up to this full range of punishment. This will be for a 10-year period, but you pay restitution back and I can end it in a third.
Yes.
And Have you ever been convicted of anything before? All right. 5 years term, 5 years term. And again, pay this restitution back and we can get you out of there. And that's sort of. You understand what has happened tonight. Probation officer will prepare the probation report, we'll sign it, and you'll begin probation. Thank you.
You're the owner of our house.
Yeah.
What we have that other lady.
Herbert Smith, and we're just gonna have some weeks on him. This is
Herbert Smith. Where's Herbert?
Did he change it to 5 years? Okay, you want to make sure?
All right, Herbert August Smith, here in 26 CR 526. You were charged with third-degree felony of operating a motor vehicle in a public place while intoxicated. And it's a felony because you have 2 prior DWI convictions out of Jefferson and Orange County, Texas. And then would. Yeah, you were in a crash of your own car. Looks like a one vehicle crash.
Yeah. The bar was broke.
Sir?
Ball joints broke. Ball joints broke of the vehicle.
Yeah, ball joints broke. You were also 2.5 times the legal limit of intoxication. That's what caused everything. Don't give me the ball joints. You were intoxicated. 380 proof bottles of Paul Masson brandy were in your pockets. And that's your 3rd time for a DWI. You see a consistency problem here that needs to get worked on? Yeah. What today?
Just reset pregnancy.
Okay. So he was indicted on 4 weeks ago. Yes, all right, let's get a reset. You have, did you drive up here today?
No.
Who drove you?
I got Uber.
Who?
Uber.
You did Uber?
Yeah.
Okay, because you can't operate a motor vehicle unless you have an interlock device. You understand?
Yeah.
Do you have one in your car? Okay, which you have to blow into or something before it starts, correct?
Yes.
That has to, if I catch you without one of those during this period of time, what would happen is your bond would be revoked and you wouldn't have a bond. You'd sit it out in jail until we get this thing accomplished. That's because too many times, that's a 4,000-pound missile. Too many times you have people weeping and crying because people get hurt or killed for actions that are irresponsible in the usage of motor vehicles. And in here, you have an order of the court not to operate one unless you have the interlock device. Okay, Alicia Simeon.
You just asserted that.
Yeah.
I'm signing these, Alicia. And we're going to, among other things, there's going to be a theft prevention class that you're going to have to take. One of the things, and that's a good one, a theft prevention class. And there are a lot of conditions here, but most of these are the things I have to follow too. So it's not like these are additional efforts that you're going to have. Most of these are the things that we all do to follow the laws for the most part. Okay, I'm giving this to the probation officer. She'll go over those with you and you'll begin probation. Good luck. Thank you. Daniel Rodriguez.
I think Greg was talking to him outside and to the probation office. I'm too late here.
Don, are all of yours done? Don, where's Mr. Rodriguez now? Come on up.
It's not a deferral. It's straight up.
Okay.
It's an offer 205. He doesn't have any criminal history, so I don't want. I hadn't had a foot on the conviction. I'll take it. It's going to be conviction and the jury can do it. That's basically nothing to I'm not just being flippant here, putting another trial for no reason.
Did you read the probable cause evidence?
I understand. What,
no, did you read it? It's a disturbing. Oh, that's all.
You look at that, a little bit of
Yes.
Yeah, no criminal history. I'm not talking about, and he's not either said any of the felony conviction with this one. Deferred would be entertained much more seriously, but not a.
It's 3 hours for the police to get him out of the house, and had a high level of intoxication, and was fled. And police met him and fled in his house and barricaded himself. Yeah, and so. And they have a video. The police have a video.
Yes, Judge.
Okay.
That's why the offer is made. Don't
I can understand that. All right, good. Here's the deal. We're going to it'll be set for trial, and on my watch, that's what you get. That's your choice. We'll let a jury make this decision. Let's get this thing moved fast because it's a family matter.
Okay.
We gotta get this fixed for the family, one way or the other, and we do it hastily. Okay.
Well, I gotta say, we was entertained deferred.
She's not making it. It's going to be a trial. If you're convicted, it's convicted. You know, you don't get deferred to the jury, but it's the state's offer. They're the ones that make the decision. But just because you're eligible for probation doesn't mean that the jury's going to give it. But it's still a conviction if you're convicted, whether they place you on probation or not. So still freedom. And here's the deal. Are you living there with the family?
I'm instructing not to.
I'm sorry. You're ordered. Or do you have any contact with the victim?
I'll represent to the court the
child. I'm talking to you, sir.
He has a Fifth Amendment right to remain silent. We're starting a right to remain silent.
Okay. What is his bond? His bond will be revoked because this is a matter of a condition of bond. I'm sorry, I'm speaking, sir. Let me finish speaking and then you can talk. She can't take this down. A condition of bond. A condition of bond is you shall have no contact with the victim. If you're having contact with the victim, that's a violation of the bond.
Contact.
There's
no allegation from the state that he has.
I don't care. I'm asking that. It's my bond condition, sir, not theirs.
But he has a right to remain silent, Your Honor. Sir, contest that, Your Honor.
Do you have any contact with the victim?
I'm saying on my own.
I just
don't understand.
He has a right to remain silent.
I have a right to enforce the bonds that I set under a court's order.
The state has evidence that he's violating a bond condition. They can bring it forward to the court.
I'm sorry, it's my bond order.
There's no evidence that he's violated the condition.
Sir, you've made your point, but this court can also do its own work. It needs to ensure that its bond is being enforced. It's not your bond. Okay. Anything else?
He has no contact. No.
That's what you're saying.
Correct.
Okay. Do you understand if you had contact without the court's permission, that would be a violation of your bond, and your bond could be revoked?
Yes, sir.
As long as you know that.
Correct. You don't feel the obviously.
Okay. All right.
So.
And don't interrupt this court again when it is trying to enforce its bond orders, which is an order of the court. You can put whatever you want on the record, but don't interrupt the court, please, which like you're doing.
I have an obligation to represent.
That's all. That's all.
And cannot.
We're in recess on this. That's all. It's just hard to deal with you, Mr. Kimler, on your insistence on interrupting, because she can't put everything down when you speak over. I know. I've known you for 40 years. I know how you are. You're a vigorous representation, but still the orders and the rules are when I speak, and you get a fair opportunity to respond. And just follow that. That's all I say. End of hearing. Thank you. Do we have, Don, you had something else you're doing? Ryan, are you working on something? Okay. All right. Then we're in recess on all of this. We still have something else, right? A hearing that we're taking?
Yes, sir.
For this one. You ready?
I'm still trying to resolve one thing next door. They had a medical emergency next door.
They did.
Another pass out. This one was not mine. And I'll move. So.
Conflict does exist, given the waivers, the court will consent to hear the matters. All right, we've gotten that part out. Everybody's ready? No? Oh. Okay. I have so when do I have 14? And I'll play one more.
We need to go.
Okay. Who you have? You have both the waiver, we think. Okay. And Ms. Zenda, you ready on anything?
When Mr. Brindell is good, that one's mine. We'll be ready.
Oh, okay. All right. So you're the one actually working. Cook, what are you doing? Are we ready?
Meeting on a defendant as well as public defenders.
We have no public defenders here. Why is that? Are they all next door?
No, I checked.
They're not next door?
Not seeing public defenders next.
Seriously? What? Yes. Tell them I'm ready to go.
Consent. Pretty public.
Morning. Good morning, sir. How are you? Pardon? You're in the wrong room. Why? You don't want to see me? No, I'll do something to you if you want me to, but all right, you can go over and see the other judge. That's okay. I'm good. Take care. Is it more next door? All right. See? To make people operate on my schedule. Yes.
The only one next door is Mr. Bellinger.
We only have Bellinger next door? He doesn't have anything. Thus, does he? So where are the rest of them?
Not next door to that. That's so really already. He said when he was there, I'm going to go next door is the next judge.
Yes. See if anybody's ready. No, they got okay, that's 7 or 8 next door. How many in custody do we have? 1?
Yes, got it. So a long time.
Got it.
You just started me. It's called.
Show Miss Zenda, the moment you leave the room, I'm going to call your case. All right. Wow. Yeah. Get something done today.
Yeah.
Where's Ann? I get. But why is that taking so long?
Did you already like it? But it, he was awesome. Really? How can I help you, Your Honor? So Mr. Dunaway and Mr. Levy are they were talking to the prosecutors. Judge Moore's not on the bench yet, though.
So Judge Moore is not on the bench. I'm on the bench. They're next door talking. All right. I would bet if I started issuing bench warrants, they'd get over here. You think? One like. Take care of Mr. Cook. He's been here ready to go.
Yeah.
You can come on in. Nothing's going. Yeah, I don't know what they're doing.
Yeah. Yes, we do.
I have more officers than I do attorneys.
Just give it the single number. All right.
Hello, Ms. Gaines. Are any of your people ready?
Yeah.
Good morning.
So, Your Honor, my understanding is that Mr. Cook is ready on Reed with Ms. Gaines' case, if Ms. Gaines is ready.
Reed? Are you ready on Reed, Ms. Gaines?
Super prosecutor, Your Honor.
Sure.
You might be new district.
Oh, they'll be ready. That's freedom.
No, they're not. It's from West York in German for the jail. It's wrong. This client is going to be like, Sir, my husband's assaulting officer.
Looks okay. There are prosecutors everywhere. I have no defense attorneys.
You got it.
Well, no, I could do with less prosecutors, especially since Kennedy walked in.
It was.
Yeah. Help.
1-ANDERS what appeared to be nitrous oxide.
What did you do when you saw the defendant?
I told them to stop and put it down. And he continued to.
Did the defendant say anything at that time?
He told me
working that day? And were at any point were you dispatched to 2931 Carpenter Road?
Yes.
Is that here in Washtenaw County? What were you dispatched for?
male screaming obscenities, disorder.
Were you with anyone else or was it just yourself?
At the time of arrival, I was by myself.
What did you do when you arrived at that? Or can you describe what's at that location?
It's an abandoned lot. The call came in with a neighbor from a neighboring business, a nail salon. That was a complainant that the male was located in an abandoned lot next to say.
When you say the male was in the abandoned lot, who is the male? And you sort of gestured a little bit. Can you point to and identify, or do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing? The record may reflect this witness has identified the defendant.
That objection record shall so reflect.
Where did you find the defendant?
We against, or sitting down on the ground against a 3-foot brick wall. Side of the abandoned lot.
How far was that from the business that you said made the call?
Like 35, 40 yards.
All right. What was the defendant doing when you meet or when you first saw him?
So I rounded the corner. He was actually puffing what appeared to be nitrous oxide.
What did you do when you saw the defendant?
I told him to stop and put it down. And he continued to.
Did the defendant say anything at that time?
He told me for my French to fuck off, and I told him to stop, to put it down. Then he told me to suck my dick or suck his dick.
Did anyone else ever arrive on scene to assist you?
Officer Gonzalez did.
Do you know what Officer Gonzalez's first name is? When did Officer Gonzalez arrive on scene?
Shortly after I made initial contacts, as he was argumentative, and so I asked her to step it up, and she arrived very quickly after.
While all of this is happening, what were you wearing at the time?
His exact uniform, the Class B department issued.
And I see there's some patches on the shoulder. Are those your police patches?
Yes.
What were you doing, or what did you do with the defendant at that point?
At what point?
So you said that he made some expletives. What did you do after that?
I asked for my partner Officer Gonzalez to step it up, due to him being under the influence, what appeared to be, nitrous oxide, actively huffing at his argumentative behavior towards me, dislike for the PD or whatever. I asked her to step it up. I attempted to grab the nitrous from his hand at that point. He, turned away from me and kind of tensed up, due to his physical nature. I wasn't comfortable going hands on with him. My partner.
At any point, did you put hands on the defendant?
Once Officer Gonzalez showed up, yes.
What happened when you put your hands on the defendant? Why? Let me rephrase that question. Why did you put your hands on the defendant?
I attempted to stand him up to take him into custody for something.
At that point, had the defendant been resisting you physically?
Not physically. Well, I mean, he had tensed up, but.
Was he actively fighting back at that point? At any point, did the defendant start to fight back?
Yeah, he came to kind of push off of us, stood up very aggressively, and then eventually charged Officer Gonzalez.
Said charged Officer Gonzalez.
Other than charging Officer Gonzalez, did he make any other, or did he physically resist in any other way at that point?
Prior to him lunging at Officer Gonzalez.
Oh, so you said he charged, and now you're saying at some point he lunged?
I'm describing pretty much the same, but
okay.
Yeah, he ran towards him.
Did the defendant ever swing at either you or Officer Gonzalez with his fist?
Not at me personally. He did when he ran at Officer Gonzalez. It appeared to me that he was getting shoved or pushed her.
Did you hear if Officer Gonzalez ever exclaimed anything about being attacked?
She advised that
it's an excited utterance, Your Honor.
Overruled. Go ahead.
She advised that she was struck in the face by Mr. Davis.
Did Officer Gonzalez ever exclaim anything about the defendant grabbing her?
Objection hearsay again, unless it can be contextualized, if it's claimed to be an excited utterance.
Well, they're engaged with a suspect at that time. What do you mean contextual?
Well, he's just asking a general question about what she said. We don't know the timing in which she's saying it. If it's not an excited utterance.
During the engagement with this defendant, that the statement would come. Just okay. Overruled. Go ahead.
Other than him pushing her while he was still seated on the ground while we were attempting to get him up, she did say out loud, "Stop squeezing my hands," or stop.
What did you do after the defendant lunged at Officer Gonzalez?
I took my department entry taser 7 out of my holster. I activated it. Once he made contact with Officer Gonzalez in an aggressive manner, I deployed my taser.
Was that taser successfully deployed? After you deployed the taser, what happened then?
Mr. Davis fell to the ground. Some verbal orders to roll over under the stomach and place his hand behind his back, and he did so.
At that point, or following that, was the defendant cooperative?
He's very argumentative, but yes, he was much cooperative after that.
While all of this was happening, did you have a department-issued body-worn camera?
I did.
And did that camera capture what happened during this incident? If you saw that footage, would you be able to see it and recognize it? I can have just 1 second here while I get this set up. My apologies.
And
Plugged in, if I can put up my screen for authentication purposes. And there we go. Sir, do you recognize what's on the screen right now?
My body worn camera showing the dash of my car.
And this is part of a video, is that correct? Is this video fair and accurate representation of what occurred during this incident?
Yes.
Are people move to admit with March Simpson proposed exhibit 1?
The objection of what here?
No objection, Your Honor.
Exhibit 1 is admitted.
Thank you. Permission to publish?
Yes.
So 20, for the record, it's 26 minutes, 34 seconds. I'm not going to play the whole video. I'm going to play just the first few minutes that captures the incident. And I'm beginning from 0.
Okay. I would wall one right there, you know, guy sitting right on the other side of it. And pull up here and he's just screaming. Like blood curdling screams, fuck you, and there's nobody around it. On this thing. It's just. See if I can try to. All right, put it down. Oh. Most awesome. Yeah. What am I myself? Hey. What am I doing? You're using reference television. I don't know where to stop. Yeah, it's just something there, fine. Yeah, I'm not going to see. There's behind back. I'm behind you back.
Going to pause the video at 3 minutes and 8 seconds there. We can take me off, please. Sir, there was a female officer in that body worn camera. Was that Officer Gonzalez? If I can have just one moment, please, Your Honor.
Pass the witness, Your Honor.
Cross-examination.
Hi.
Officer Anderson, you testified, first of all, this area where you found Mr. Davis was this vacant lot. And that's on the corner of what, Carpenter and Packard?
Yeah, Crystal Packard.
If I show you a couple of photos, just to have some still shots of this. Would you be able to identify that location? These are A. Which one's tagged? I've marked proposed defense exhibits A and B. May I approach the witness, Your Honor? Thank you. You recognize what's depicted in those photos, sir? And does that appear to be the front and back area, for lack of a better word, of that brick wall where you found Mr. Davis?
Yeah, the east and west side.
Okay. Your Honor, I'd move for admission just for the location.
No objection.
Exhibits A and B are admitted.
Thank you. Officer, at some point in the video, we see you taking a couple of bags or trying to take away the canister from Mr. Davis. Is that correct? You testified that it appeared to you that the canister he had in his hands was nitrous oxide, right? And at some point you confiscated those items and other belongings and you took photos of those. Is that correct? You got a picture, that'll be C. And as far as evidence of what you were arresting Mr. Davis for, possession of drug paraphernalia, is that what you confiscated these bottles for? Okay, may I approach with exhibit C, proposed exhibit C, Your Honor? Right. Thank you. Just for purposes of the record, is that the photo you took of the property that you took from Mr. Davis?
Sorry. Yes.
Okay. Move for admission of exhibit C.
No objection.
See if you admitted.
When you arrived to investigate Mr. Davis, it was what, around 11:30 a.m., somewhere in that ballpark? And as we can see on the video, it was broad daylight out, correct? You estimated the distance from the neighboring business where you spoke to the gentleman that we saw in the video, 35 to 40 yards or so. Is that fair to say? Is it also true to say that when you came upon Mr. Davis, he was alone against that brick wall? And there's nobody out in that vacant lot or on the side in the grassy area there? And didn't anything else on his person, Mr. Davis, such as a weapon or something that would make you think he was a danger to you or anybody else in the area? Did you? Okay. Also, do you know in that, so there's that grassy area, which would be the east side of that vacant lot. Do you know how far that brick wall is from the road itself, that side street?
I'd approximate like 50 foot.
Okay. You would agree it's quite a distance, more than just from here to the court clerks. Okay. And just to be clear, I assume you didn't see anybody in the roadway that was also complaining of Mr. Davis. Okay. When you came upon Mr. Davis, and we saw in the video, it doesn't sound like he is yelling or screaming at that time, right? So he just appeared, as he did on the video, sitting up against the brick wall and essentially minding his own business.
Yeah.
Okay. Again, just to be clear, did you see any sort of no trespass signs or no loitering signs in that particular area? When you came upon Mr. Davis and you saw him inhale from that nitrous oxide canister, did you believe that that was illegal to possess nitrous oxide?
Using that form.
Okay. And that possession of nitrous oxide or him using it by inhaling it, that was the sole reason you were, I believe, as you said, attempt to stand him up so you could arrest him for huffing, correct? And ultimately, you gave Mr. Davis a citation for possession of drug paraphernalia, nitrous oxide. Is that correct?
I did not.
You did not. If it has N. Anderson on the bottom of that citation, that not be you? Okay. If you take a look at this, may it refresh your memory? May I approach, Your Honor? Reviewing that, does that refresh your memory that that was the citation you issued against Mr. Davis? And is the sole charged misdemeanor possession of drug paraphernalia? All right. Just for purposes of the record, I would move for admission of defense exhibit D, as in David.
No objection.
Exhibit D is admitted.
One of the things we saw on the video is, I believe, before you make physical contact with Mr. Davis by grabbing his arm, you took, it looked like bags that were next to him. Is that correct? What were you doing at that point?
His property away from him. Unknown what was inside and could have been had anything in it. And then his altered state, he did belong to positive jurors.
Okay. And in this particular case, you did draft a police report, correct? So essentially, that is a detailed recollection of the things that you felt were important about this situation. Prior to making contact with Mr. Davis, did you have any awareness of the effects that inhaling nitrous oxide could have on a person? And what was that awareness?
Sometimes when someone's under the influence or it can be aggressive and unpredictable.
And so you had that knowledge leading up to your interaction with Mr. Davis, correct? You saw him huff from this nitrous oxide bottle. And then it looks like while he's sort of in the middle of, for lack of a better word, being impaired by this, you and Officer Gonzalez are making physical contact and trying to get him to stand up so you can arrest him. Wouldn't you have had the option to simply wait and maintain some distance, given before you did anything physical with him, given the fact that he's alone in this area where there's nobody else? Wasn't that a reasonable option? Because prior to making physical contact with him, he was just sitting. He was maybe saying things that were
Sitting and committing a criminal offense.
Well, I guess that's yet to be determined.
No, because if the inhalation of a chemical agent is a criminal offense in Michigan.
Well, I guess that's the question. Is it a chemical agent? And proposed exhibit number E. That's the last.
You referred to it yourself as nitrous oxide.
Yes, Your Honor.
Do you know the statute?
Well, the criminal charge that was charged against Mr.
Doesn't matter whether it
Was
was charged. It's the offense itself that the officer's viewing. The inhalation of a chemical agent for the purposes of euphoria, excitement, whatever, is a crime.
Well,
So if that's where we're going,
I guess that's,
please get there quick.
I'll save that for argument then. If
Well-
I may approach with the final exhibit.
Go ahead.
Thank you, Your Honor. Mr. Anderson, were you aware that the citation and the charge of possession of paraphernalia was ultimately dismissed in this court? Okay, that's okay. If you don't know, I would just move for admission of defense exhibit E. It's an official court order of this court, just for purposes of the record that according to the order, it's dismissed because the ordinance does not prohibit this conduct. And I believe it's admissible for purposes of the legality.
Ordinance doesn't. But for Pete's sake, any objection?
I would object to those, but I think the court could take judicial notice of it since it's from this morning and easily accessible with court's information, but.
And that's all I'm at.
I don't know what it's gonna matter, but what the heck, we'll just admit it. You do understand that state law is different than an ordinance, and that a determination under that was made that it did fit the ordinance. That doesn't mean that there wasn't a crime. You do understand that.
I understand the distinction, but I would also argue that inhaling nitrous oxide is not a violation of state law.
Really? I can't wait to hear that. All right, go ahead.
All right, thank you, Your Honor. Officer Anderson, would you agree with me that prior to making physical contact with Mr. Davis, he was sitting stationary, doing his own thing? In other words, he wasn't getting physically aggressive or combative toward you or Officer Gonzalez until either one or both of you attempted to make physical or did make physical contact with him, correct? All right. And at one point in the video, we see, well, we hear Mr. Davis say, "No, I'm not going with you." Remember hearing that? And that would have been an expression where he's essentially saying, "Leave me alone. I'm going to stay here." Yes? Was there, when you heard the things Mr. Davis said that nobody would like to hear, was there any attempt by you or Officer Gonzalez to engage in further conversation or de-escalate the situation so it didn't get physical? Did either you or Officer Gonzalez, before making physical contact with him, identify yourselves as police officers?
Not personally.
Did you or Officer Gonzalez, before making physical contact, simply ask him to leave on his own accord, get out of this area?
Because he was breaking the law, so we were going to take decision.
When you saw that Mr. Davis was had huffed, and as we said, for lack of a better word, under the influence of this, had you or Officer Gonzalez radioed for HVA paramedics? And was there any? I'm sorry.
Officer Gonzalez.
Okay. And so you knew they were on their way. And would you not have been able to simply maintain a controlled situation to allow them to come in and do a medical check before you made physical contact with Mr. Davis?
You can inject speculation. Don't know what.
Sustained.
Final few questions, Your Honor.
Let's hope.
When we see Mr. Davis get up from the wall after you and Officer Gonzalez made contact with him, did it not appear to you that he was attempting to walk between the two of you before it appears that Officer Gonzalez pulled out a taser on him?
Yeah.
Okay, was there a space between you and Officer Gonzalez that he could have walked through? Would you have allowed him to walk through? Okay. After Mr. Davis was tased, and we saw in the video, he's on his back, you tell him to roll over, takes him a few seconds, but he does so, correct? Tell him to put his arms behind his back. Once he takes a couple seconds, he does that, correct? And as you testified, he was cooperative after that point and onward.
It's perfectly argumentative, but yes.
Not physically resisting. Okay. And you're, again, actually, I'll withdraw that question. No further questions, Your Honor.
Any redirect? Just have two questions. Officer, how many different markings are on your uniform that identify you as police? And
bag. That big silver thing in the front. Yeah, got it.
Was Officer Gonzalez wearing the same uniform as you're currently wearing? Nothing further, thank you.
Had a big badge. Yeah, okay, just checking. Anything else?
Nothing.
Officer, you may step down. Thank you.
People have no further witnesses.
Defense has no witnesses, just argument.
People move for bind over on the information. I believe it's just a single count of resisting and obstructing. Court heard testimony and saw the video of this incident where the officers were attempting to apprehend and arrest the defendant for violating MCL 752.27. That being the inhalation or consumption of chemical agents, including nitrous oxide. I believe that arrest or that attempted arrest was lawful, and the court saw the defendant lunge at Officer Gonzalez during the commission of those duties. Certainly, he knew that these were police officers based off of the numerous markings indicating that they were police officers. Knew that the amount of force they used was reasonable, especially when the court again saw the initial attempts at just standing him up gently, getting him on his feet, and then he became aggressive. I would ask the court bind over on the information.
And so that you can frame your argument, I think that it's appropriate that actually there be two counts of resisting and obstructing, but go ahead.
Your Honor, under the resisting and obstructing statute, one of the elements that the Supreme Court has recognized is also an element for purposes of bind over is that the police officer gave the defendant lawful command, making a lawful arrest, otherwise performing a lawful act. And in various statutes, it talks about if a misdemeanor offense, which has a punishment of more than 92 days incarceration, then a person can be arrested for that by statute. That's 76415. The case law, and I'll get to the chemical agent, but my argument essentially, Your Honor, is nitrous oxide is not a chemical agent. But the first part of that is,
where does that come from?
752271. And there's two areas.
Does it specifically delineate that nitrous oxide is not a chemical agent?
It does not, but by its description, the definition of chemical agent, 752.271, as used in this act, the act is what prohibits, for the purpose of causing a condition of intoxication, intentionally smelling or inhaling the fumes of any chemical agent. And it's defined as any substance containing a toxic chemical or organic solvent or both, having the property of releasing toxic vapors Term includes, but is not limited to glue, acetone, toluene, carbon tetrachloride, hydrocarbons, hydrocarbon derivatives. Nitrous oxide is not included. I understand though, it's the statement is includes but not limited to. But nitrous oxide is not a chemical agent because it does not contain a toxic chemical or organic solvent. And if I could.
You realize nitrous oxide is toxic to humans?
It's used at dentist offices. It's not toxic to humans. It's a compound, but it's not a chemical agent as defined by the statute. And I think the fact that another part of that same section, 752.272A, prohibits people from selling. Here's the statute. Part 1, persons shall not sell or distribute a device that solely contains nitrous oxide to a person under the age of 18 for any purpose. It prohibits people from selling these things to minors. But nowhere in the statute does, when this statute specifically is directed at nitrous oxide, nowhere does it prohibit the adult use of nitrous oxide. And so when a statute directly addresses something like this particular substance, but does not prohibit the use or possession by adults, then I believe the statutory can't.
So what do we do with dust off?
What do we, I'm sorry?
Yeah, I mean, as an adult, I can go in and I can buy dust off all day and night long to the extent I can find it.
Yeah, it's not.
But not mining.
That's what the statutes are focused on. And I think because there is no statute that prohibits the use or possession of nitrous oxide by an adult, then
it's the chemical agent. It is not. Go ahead.
It's presumably legal, especially when there is a statute that is directly focused on the sale and distribution of nitrous oxide as illegal to minors. But why wouldn't it mention anything about the possession or use by adults? Because it's not a chemical agent.
No.
That's my argument, Your Honor.
Yeah, I hear it. I don't know that that's an argument, but that your logic is incredible to me.
Well, let me just finalize this by saying the reason the 2 officers arrested, as was testified to, Mr. Davis, they wanted to stand him up and arrest him for possession of drug paraphernalia. He was cited for that. That was dismissed. That's in the court record. And the dismissal order indicates because it's not illegal.
So, Mr. Farfelsky, let me ask you a question. Let's presume in one of the 9th rounds that you're correct regarding nitrous oxide. When the officers come to investigate, ask him to stand up, or asking to identify and just investigate what they may perceive as a crime. And I think the case law is rather clear. When they're investigating, even if incorrect, that doesn't make the command or what they ask unlawful. So at that point, while they're investigating, are you indicating to this court that the offense of, first of all, grabbing Officer Gonzalez, again, not complying with Officer Anderson, and then charging at Officer Gonzalez doesn't fall under the statute of resisting and obstructing?
Well, Your Honor, the case law on this element of...
Are you arguing that?
I'm arguing that because this element of resisting also implicates Fourth Amendment search and seizures issues, and that's straight out of People versus Morosky, 2023 case.
If the officer is briefly detaining someone to investigate the potential of a crime, gets charged at, Are you saying it doesn't fall under the statute? Yes or no?
Yes, because the police precipitated a situation that did not have to occur. That prior to getting the police officers getting physical, making physical contact with Mr. Davis, he was minding his own business. And it wasn't until they laid hands on him, tried to physically seize his person, detain him, and then pull out tasers, that I would argue he had the right to resist an unlawful arrest, because at that
He
point,
had the right to charge as that Pittsfield officer. Is that what you're telling me?
I'm not saying that, but
Is that what you're telling me?
protect himself from a taser.
Please finish your argument.
That's it, Your Honor. I would object to bind over for those reasons.
Anything from the people?
I believe the court has the power to add charges that it seems fit. If the court wants to find over on additional charges, the people have no objection to that.
Court has listened to the testimony in this case of Officer Anderson. Officer Anderson is called or is dispatched to the location as a result of a citizen's complaint. You can hear the individual say what is going on. The officer goes over, sees that. I do not believe by any stretch of the imagination under the circumstances of that use of nitrous oxide, that does not fall under the statute of 752.272. He's inhaling it. You can actually see him on the video inhaling it. The officer tells him to stop. The officer, even if at that point, if the officer's incorrect as to what it is, while the officer's investigating that, the officer is giving a lawful command so that he can fulfill his obligation to investigate what's going on. Officer Gonzalez arrives. What is then further clear is that they get him up. He then charges at Officer Gonzalez. They have to take him down and they have to tase him. I don't know under what argument that the defense says it's okay while an officer's even just minimally investigating the potential of a crime, that officer could be charged at and physical contact made with that officer. If you show me some case law that indicates that, then I won't bind over. But you don't have it because that's not the law. Plain and simple. People have indeed sustained their burden of showing that the defendant has committed the offense of resisting and obstructing police officer and first responder on count one, that being as to the resisting and obstructing as to Officer Gonzalez, the 2-year felony. The court is going to add an additional charge of resisting and obstructing a first responder for his conduct as it relates also to Officer Anderson, as the court believes that all of the commands that are given by Officer Anderson while initially going there, and then as he is further giving commands to him at the time that after he, and I'm plain spoken, at the time that he attacked Officer Gonzalez, all of those lawful commands he did not abide by at all and did not comply with. And so the court believes that an added count 2 of assaulting and obstructing a first responder police officer is proper. The defendant is bound over to stand trial on counts 1 as pled and count 2.
Your Honor, as to arraignment, waive formal reading and stand mute to both charges.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pre-trial in this matter will be set for
August 6th, with Judge Slick.
We may have to arrange that date. As to bond in this case, I'm going to be honest with you. I do not. This person poses a risk to the public. I see a lot of resisting and obstructing cases. it is rare, very rare, that as the officers engage with the person, that you see somebody charge an officer and then not comply to the point that these officers then have to deploy their tasers. And had they not, quite frankly, as he's coming at Officer Gonzalez, I don't believe he would have stopped. So you tell me why this person isn't a danger to the public, and I don't know why he has a PR, quite frankly.
Your Honor, I don't believe my client has any prior convictions. I know that he is in close contact and supported by his family. I've spoken to his mother. While he's been on the current bond, he's had no issues whatsoever at all, always appearing. I believe he's testing at community corrections, and I don't believe there's been any issues. So I don't see that there's anything that has changed given the fact that he's been absolutely compliant with the sports bond orders.
If there's anything from the people, I really don't need it, but.
I would note that the people's original request did not include a monetary component. The original request was just for a conditional release, that being with some alcohol and substance abuse testing. I know that he doesn't have any prior criminal history. Ultimately, based on what the court heard today, if the court thinks that a monetary component is appropriate, I'm not going to object to that. I will leave it ultimately to the court's discretion.
Anything else?
As far as that, Your Honor, my client, I believe, works at a coffee shop. Or doesn't currently have a job. He was terminated a couple of days ago, but he wasn't making much money. He doesn't have much in the way of resources for a cash bond. And again, he's been absolutely compliant. There's been no safety issues in the community or with this court or anybody else.
If you run at an officer in the fashion that he did, he is a risk to the public. Bond is set in the amount of $15,000 cash. Surety defendant is remanded. Give me an in custody date. Pardon? The date is still the same. August what? August 6, 2026, 9 a.m. before Judge Slay. Thank you. Court's in recess.
All right.